Welcome back to the 2022 Missouri Law Review Symposium, the two impeachments of Donald J. Trump. This is the second panel, and our panel title this morning is The First Trump Impeachment, What is an Impeachable Offense? I'm Justin Dyer. I'm a political science professor and director of the Kinder Institute on Constitutional Democracy at the University of Missouri, and I'll be chairing this panel this morning. President Trump was first impeached on December 18th, 2019. The two charges were abuse of power and obstruction of Congress. On those two charges, President Trump was then acquitted by the Senate on February 5th, 2020. And this panel this morning will begin with a big picture question related to that first impeachment. The question will very likely take us beyond it to the second impeachment, into the question of impeachment generally. And we're focusing in on what an impeachable offense is, but that's going to implicate several other lines of inquiry, including the constitutional structure and meaning of impeachment, legal defenses against impeachment, including potentially First Amendment defenses, whether someone may be impeached after leaving office and what that would look like and what a trial would consist of. And then, of course, the broader constitutional politics of the impeachment process. And this morning, we have three distinguished panelists to address these questions with us. We'll give each panelist 15 minutes. At the end of that time, we will then open it up for Q&A. Our first panelist is Keith E. Whittington. He's the William Nelson Cromwell Professor of Politics at Princeton University. He's currently the chair of Academic Freedom Alliance. Two of his most recent books include Repugnant Laws, Judicial Review of Acts of Congress from the Founding to the Present, and Speak Freely, Why Universities Must Defend Free Speech. He's been a visiting professor at Harvard Law School, Georgetown University Law Center, and the University of Texas School of Law, and he's a member of the American Academy of Arts and Sciences, and he served on the Presidential Commission on the Supreme Court of the United States. Keith, welcome.
Thank you. Appreciate being able to participate in this. I'm sorry we can't do it all together, although now it sounds like there are weather-related reasons as well as COVID-related reasons not to be there in person. But it's a great group for the symposium.
Great. And let me go ahead and I will introduce our two other panelists as well. And then Keith, I'll turn it over to you. Our second panelist is Michael W. McConnell. He's the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School. He's a senior fellow also at the Hoover Institution. From 2002 to 2009, he served as a circuit judge in the United States Court of Appeals for the 10th Circuit. He's argued 16 cases in front of the United States Supreme Court. He's published widely in the fields of constitutional law and theory, especially church-state equal protection and separation of powers. And his most recent book is The President Who Would Not Be King: Executive Power Under the Constitution. Welcome, Professor McConnell. And our final panelist is Kate Shaw. Kate Shaw is professor of law at the Benjamin N. Cardozo School of Law. She's written extensively about the presidency and about the law of democracy. Her scholarly writing has appeared, among other places, in the Columbia Law Review, the Cornell Law Review, the Georgetown Law Journal, and the Northwestern University Law Review. And her popular writing has appeared in the New York Times, the Washington Post, Slate, Time, and the Atlantic. She's a contributor to ABC News, and she co-hosts the Supreme Court podcast, Strict Scrutiny. Before joining Cardozo, she served as an associate counsel in the White House counsel's office, and she also clerked for Justice John Paul Stevens and Judge Richard Posner. And so we are delighted, Professor Shaw, to have you with us this morning, and for all of our panelists today. What I'd like to do is go in the order of our program. And so it will be Whittington, McConnell, and then Shaw. And we'll give each of you 15 minutes or thereabouts to offer some reflections on the question, what is an impeachable offense? And then we'll open it up for conversation among the panelists and questions from our audience. So Professor Whittington, I'll turn it to you.
Great, thanks. As you suggested, there's lots of important questions that arise out of even the first Trump impeachment. The second one creates a whole new set of interesting questions. There are important process questions relating to the impeachment power that were relevant in thinking about the first Trump impeachment, and that the first Trump impeachment has some implications for how impeachments might play out down the road. But I do mostly want to focus on substantive issues of thinking about the nature of impeachable offenses themselves and what the implications are for the specifics of the Trump case. I think this breaks down into three kinds of questions. I mostly want to focus on the first of these three, but I'll touch on the others. The core one, of course, is the most general, which is simply what is an impeachable offense under the federal Constitution, which notes a standard of officers being able to be removed by impeachment by the House and conviction by the Senate for treason, bribery, and high crimes and misdemeanors. The second kind of question, though, is this particular kind of behavior impeachable? Even if we know what the general category of impeachable offenses looks like and the basic standards as to what counts as high crimes and misdemeanors, there's still interesting questions about how to apply it in particular situations, including the kind of situation at stake in the first Trump impeachment. And finally, does this particular instance of misconduct actually justify impeachment? And then I think, secondly, for the Senate, does it justify removal? I do think that there's a discretionary power on both the part of the House and the Senate, that even when they see themselves as being confronted with an officer who might be engaging in impeachable offenses, there's still an additional question they need to ask themselves, which is impeachment the appropriate remedy for the particular problems that they see in front of them and the kind of misconduct that they are confronting? The answer will sometimes be yes, but I don't think the answer is always yes. That impeachment necessarily ought to follow from the identification of the misconduct at heart in a particular situation. I do think in the Trump context, including in the first impeachment, impeachment was justifiable given the conduct at issue. But I do think it's a question the House needs to be thinking through as it's deciding whether or not to actually file articles of impeachment, whether or not to advance them to the Senate. My starting point for thinking about these kinds of questions in general is to emphasize the extent to which the impeachment power is part of a broader system of constitutional checks and balances. This is a mechanism designed by the founders to be able to facilitate the ability of Congress to keep other government officials in check and within the scope of their own constitutional authority. When the founders are thinking about creating an impeachment power in the first place, it's the presidency that's very much on their mind as being a central office that particularly might need an impeachment power in order to potentially deal with abuses that officer in particular might engage in and might be otherwise very hard to check or limit. Obviously, there are lots of other checks that Congress has in its arsenal to deal with an abusive office holder, including and maybe particularly the President of the United States. Is one reason why when Congress is confronting instances of misconduct, it needs to be thinking through out of that arsenal of tools they have in order to address misconduct and try to check presidential abuses. Is this the particular tool that's best suited for the job and the kind of misconduct they're confronting? But it is importantly part of that arsenal. It is part of the mechanism by which Congress is supposed to be keeping the president within constitutional bounds to remedy abuses of office when they see an office holder, including the president, engaging in it. And importantly, I think to defend congressional prerogatives. That is, the impeachment power is part of the toolkit that Congress has to ensure that Congress can do its constitutional job and execute its constitutional responsibilities. Often that's not terribly relevant to the kind of historic impeachments that we've seen across American history. It was relevant in the first Trump impeachment, in particular Article 2, which raised questions not only about whether or not the president was abusing powers and engaging in misconduct, but more particularly, was the president doing things that were subverting Congress itself and how Congress ought to operate and the ability of Congress to perform its own constitutional functions. And that alone, I think, creates a very good reason and necessity in some cases to pursue an impeachment against an office holder who is engaging in that kind of misconduct. Moreover, it's worth noting that impeachments, and this becomes particularly relevant as we think about the second Trump impeachment, because it became relevant in thinking about late impeachments, but I think it's relevant in thinking about every impeachment as to what are the range of purposes that you're trying to serve by using this particular tool in the congressional toolkit. Obviously, one potential goal is to actually remove the office holder. If you think that the kind of damage they're doing, the kind of abuses they're engaged in are dangerous enough and require enough response that they actually need to be relieved of power in order to secure the safety and future of the republic, then obviously getting a Senate conviction and removal becomes essential to that process. But I think importantly, that's not the only goal that the impeachment power can be used for. That sometimes the goal is precisely to remove an officer, and if you can't do that, then the whole thing has to be seen as a failure if you were attempting to do that. But it's also true that impeachments can serve other functions, and we shouldn't lose sight of them because they're sometimes quite important, sometimes at the same time that we're trying to remove an official, and sometimes even instead of a primary goal of removing an official. So the impeachment power is, for example, a crucial mechanism for trying to expose misconduct by particular officials. It provides an inquiry by the House of Representatives and ultimately through a Senate trial in which we can investigate how an officer has conducted their responsibilities while they hold political or governmental office. And moreover, especially in the context of a Senate trial, it provides that office holder an ability to defend themselves and explain what behavior they've actually engaged in, to rebut factual allegations about what kinds of misconduct they might have been involved with, but also to argue potentially that even if we accept the facts of the conduct in question, that conduct actually is well justified, doesn't rise to the level of being the kind of abuses that might justify an impeachment, et cetera. And so the impeachment tool is an important mechanism, obviously a relatively unusual and exceptional one, not the primary way in which we do that, especially not in the modern period, but it is one way of trying to expose misconduct by the president or by other office holders who might become the target of impeachment. And finally, impeachments can also be important for condemning certain behavior that we think is inappropriate for an office holder to be engaged in. That here the goal is primarily to convey a message to other office holders. The goal is not only to remove this particular office holder, but to condemn the kind of behavior this office holder has engaged in order to build up a set of norms about how future office holders ought to conduct themselves when they too occupy these offices. It tells us what kind of conduct cannot be tolerated and should not be repeated within the constitutional system as a whole. And notably, that can be true even if you don't wind up removing the officer in question. So even if you think at the end of the day, it's safe to leave this officer in power, there are reasons not to actually convict and remove in certain circumstances, it may nonetheless be the case that this process can allow the Congress to express in fairly firm ways that this is the kind of conduct they do not expect to see any future office holder engaging in. Unsurprisingly, I think given the nature of the allegations made against President Trump, he had defenders who argued that impeachment should only occur in the context of indictable crimes. We've seen this kind of argument made in the past. It's often the case that those who are being threatened with impeachment or who are impeached by the House, but for actions that are not indictable crimes, then want to argue that the impeachment power ought to be limited to traditional criminal conduct, and the House and the Senate should not stray more broadly. I think, though, this kind of narrowing of what the impeachment power is for and what kinds of things we ought to regard as impeachable offenses defeats the original meaning, purposes, and the ultimate history of the impeachment power and how it's been used across American history. And it subverts the constitutional design of checks and balances by taking the ultimate check on presidential power off the table. So now you're increasingly arguing that if you can only impeach presidents for indictable crimes, the purpose is no longer to allow Congress to be able to check presidential abuses of office in various ways. And as a consequence, you're limiting them to other potential checks that may be available. And maybe those checks are adequate in many circumstances, but there may well be circumstances in which those checks are going to prove inadequate. You need the possibility of being able to impeach and remove a president or some other office holder for engaging in abuse of office. And so we start limiting the impeachment power Notably, if we reduce the meaning of high crimes and misdemeanors to indictable offenses or normal criminal conduct, not only does that have implications for presidents down the road, but it has implications for every other civil officer who might be subjected to the impeachment power. So we could easily see cabinet officials or judges, the most common targets of impeachment investigations, making similar kinds of claims. And while in many cases judges actually have been impeached for things that are in fact criminal conduct, there are circumstances where we might need to remove a judge for things that are not in fact criminal as well. So just briefly, it's worth noting that the impeachment power in both British and American practice was not limited to criminal conduct historically. That was not true in the British context, in which the founders are thinking about how to make use of the impeachment power, and that they are inheriting a process that they're modifying to some degree, but taking to a significant extent from that British practice. That British practice was not limited simply to criminal conduct. And moreover, the state constitutions, as they were laying out impeachment power explicitly in their constitutional text in the period between the American Revolution and the founding of the U.S. Constitution in 1787, had a much broader focus than simply thinking about criminal conduct. They expressed what the scope of impeachable offenses were going to be in different kinds of ways, but in their use of terms repeatedly came back to terms like misconduct, corruption, and how officers are using their office. The focus is not simply on traditional criminal acts, and there's no reason to think the founders, and plenty of reason to think the founders did not, mean to depart from that general practice and understanding of what impeachment powers were for. Notably, James Madison in the Philadelphia Convention, when the founders turned to this question of whether or not there ought to be impeachment power, Madison looks at the kind of presidency that they were then constructing, which has an extraordinarily long term of office relative to their own expectations, instead of the more standard 1 year term of office that was familiar from the states. Instead, the founders were contemplating a 4-year term of office, so an extremely long term of office, relatively speaking, and a very powerful officer in the context of a presidency. It's not surprising they started thinking about, well, what happens if things go wrong in between those 4-year elections, and don't we need some kind of mechanism to deal with worst case scenarios during that period? And they quickly turned to trying to figure out then who ought to have that kind of power to deal with those worst case scenarios, and how do we define the scope of the worst case scenarios that Congress might respond to. So Madison puts on the table quite quickly this set of concerns, which are much broader than thinking about criminal offenses. He says it's indispensable that some provision should be made for defending the community against the incapacity, negligence, or perfidy of the chief magistrate. Now, ultimately, as they focus more on how to ultimately get to the standard of high crimes and misdemeanors, they start narrowing that down. But note that the initial concern and the kind of range of problems they perceive that presidents might be confronted with are quite broad. And even as they sort of narrow language and focus in on language they're happy with to define impeachable offenses, they're still thinking about many of these same kinds of problems and concerns that are much broader than the possibility of a president simply committing some kind of criminal offense while he's in office, which is a relatively minor concern from their perspective. After the Constitution is ratified, Alexander Hamilton, after the Constitution is drafted, Alexander Hamilton, in urging ratification and trying to explain the impeachment power, emphasizes impeachable offenses available in cases of abuse, a violation of some public trust. He's thinking simply in terms of abuses and trying to reassure people that even if you're going to create this very powerful presidential office, there is this important tool that can keep that kind of president in check if he turns out to be abusing office. James Wilson, another founder and early Supreme Court justice, giving law lectures at the University of Pennsylvania, emphasizes to his students that impeachable offenses should be understood quite broadly to include political crimes and misdemeanors. The focus is on how government officials are using their offices, how they're behaving in public, not simply whether or not they're engaged in some kind of criminal offense. And likewise, James Story, a later Supreme Court justice, writer obviously of a very influential constitutional treatise, similarly emphasizes the offenses that are in this category of impeachable offenses under the high crimes and misdemeanors standard includes offenses of a political character, which range is quite broad, including personal misconduct or gross neglect or usurpation or habitual disregard of the public interest in the discharge and duties of political office. And all across American history, we've largely adopted that kind of standard. That's been the practice of the House across its history. And there's good reasons why that ought to remain our standard going forward. Certainly, that's what the House argued we were confronting in the specific instance of President Trump as they're thinking about the first impeachment that involves this kind of abuse of office, this kind of effort to undermine the nature of the constitutional system, including the ability of Congress to perform its own oversight functions, up to and including exercising the impeachment power itself. I think it's critical that even if you thought that Trump, for these particular episodes of conduct, does not deserve to be impeached, and certainly does not deserve necessarily to be removed for that kind of behavior, it's critical that we emerge out of that process of the first Trump impeachment with a standard that's still robust enough to think about future possible misconduct that other government officials might engage in, and allows us to still be able to use the impeachment power when we're confronted with abuses of office down the road. So let me stop there and make sure we have plenty of time for the others, and also hopefully to get some questions toward the end.
All right, great. Thank you. Professor McConnell.
Thanks very much. Thanks for having me here. I'm going to talk about the specific charges against President Trump and the two impeachments, but I do want to preface this with this slight, not really disagreement about the overall tone of what Keith has just said, because although I think I do think on balance, the evidence is stronger that the impeachment power is not limited to criminal offenses. And I agree with him about that. But it is equally important to remember that it wasn't merely political, and that they tried very hard to come up with words to describe impeachable offenses that would be something more than political disagreement. So although Madison did speak, and in fact the original Virginia plan, which was in effect for much of the summer, spoke of malpractice and neglect of duty. They scrapped that language. The proposal was made to include the term maladministration, which was the term in a very large number of the state constitutions. That was the person who brought that up, George Mason. Upon being it was pointed out that would be effectively making him serve at the pleasure of Congress. He withdrew his own motion because he thought that was going too far. So there is a balance here. And I want to add, this isn't just sort of the niceties of what the Constitution says, which is something I care about and Keith cares about, but there's a functional point here, which is impeachments can and frequently do backfire. The idea that impeachments should be used for something other than removal because they expose misconduct, they provide for condemnation, that's, I think, a naive conception. They are just as likely to have the opposite effect. So, Andrew Johnson, by one vote, is acquitted on the ground that firing the Secretary of War was in fact within his constitutional authority and it wasn't an impeachable offense. That has gone down in precedent. We all cite that as evidence that in fact Congress decided that it is that the president has that power. One vote. Read John F. Kennedy's chapter on this in Profiles in Courage. When Bill Clinton Bill Clinton did stuff that was really pretty disgusting and bad, right? He should have been roundly condemned for it, because instead of censuring him and using other methods, they took the Republicans overreached and tried to impeach him. And by the way, I wrote a public letter condemning the impeachment back in the Clinton affair. I'm not a Johnny-come-lately to this view. Then when he was acquitted, his approval rating soars, right? It's basically rescues his presidency. So, it had and that isn't quite what has happened with Trump, but he certainly is happy to claim exoneration from the witch hunt and be able to point to this as evidence that everything was just fine. And there is a structural problem with the Constitution that leads to this, namely, when it only requires a majority vote to impeach, but a 2/3 vote to convict, I think that's a very bad feature. I'd almost rather have higher standard to impeach and then lower standard to convict. But there's a very serious problem when impeachments are not properly framed and conducted in really serious terms, because the effect of it is often to exonerate and thus to normalize conduct that shouldn't be normalized. I'm going to talk about there were 3 articles of impeachment against Donald Trump. I like to think of grounds for impeachment as falling into one of 3 rough categories. These are to call them analytical categories may be to glorify them, and they certainly aren't legal categories. But the categories are this: there's some things that really are not impeachable offenses, and for the House to impeach people for them is actually an abuse of power on the part of the House. I am not saying that is that they can be taken to court. They are the sole judge of impeachments. They can impeach somebody for stomping on a bug on the sidewalk if they want to, but they shouldn't. They should confine impeachments to somewhere in that vaguely defined category between maladministration and crime that Keith and I have been talking about. So there's some things that I think are simply not impeachable offenses. That's the Andrew Johnson case. There are some things that I think are impeachable offenses, and where a reasonable person could vote to impeach and remove, but where I can also imagine a reasonable senator voting to acquit, even if that senator believes that the president did what he's accused of in the impeachment. This is when and I totally agree with Keith that there's an element of discretion here. A very common reason why senators might do that is if they think, oh yes, he did it and it's wrong and they shouldn't do that, but he's not the first to do it. And in fact, he's being singled out for partisan reasons, not again that he's innocent. I mean, and a part of the irritating feature of the first Trump impeachment is on one side you have Trump saying, this is a perfect call, and people saying that no, nothing wrong, and then others say toss him out, when a perfectly reasonable reaction to this is that was a bad thing. That was an abuse of power, but maybe not justifying removing him 9 months before the people of the United States are going to have an opportunity to judge his actions. So that's the middle category. And then there is also a category where it's not only an impeachable offense, but it is an impeachment-worthy offense and reasonable. I think that senators who are, after all, placed on oath for the conduct of their trial should put aside partisan loyalties. They never have in American history, right? With tiny exceptions like the honorable senator from Utah. It doesn't. But if you're true to the Constitution, senators should impeach under some circumstances. Now, it is my opinion that the 3 articles of impeachment against Donald Trump give nice illustrations of each of those 3. That I believe that the second article of impeachment in the first Trump affair was not an impeachable offense. He was accused of obstructing Congress's impeachment. There are at least two things, and this is because he instructed some of his officials not to comply with information requests or subpoenas from the committee. Two problems with that. One is procedural, which is they hadn't started an impeachment inquiry. There's this ridiculously partisan dance in which Nancy Pelosi announces that there's an official impeachment, and in a press release, roughly a month before the House is ever invited to vote on whether to open an impeachment inquiry. The proper method is the House votes, then that sets up a committee, and that committee then does have the authority to subpoena. Don't just take my word for this. Peter Rodino in the Nixon impeachment affair, whom I think was a very different ilk from our modern politicians, a genuine legal statesman in Congress, he said that that House vote initiating the impeachment is a necessary step. So that's the procedural problem. But there's a substantive problem as well, which is that presidents have the right to invoke executive privilege. Now, it may be that they do not have a right to succeed on those claims, either because the particular claim is not properly grounded, or even possibly, we don't know, but there's a reasonable argument. I don't think I agree with it, but it's a reasonable argument that in the context of an impeachment inquiry, the president can't invoke privilege, period. But it isn't impeachable to raise the issue, right? To raise what he thinks is his legitimate privilege. And the proper way for the House to handle this would have been to subpoena the witnesses, consider the claims of privilege, vote them up or down. If they vote them down and the witness still doesn't testify, presumably on instructions from the president, then you hold him in contempt. And at that point, I do believe that it's certainly an impeachable offense for the president to instruct his subordinates to act in violation of in an actual contempt matter. And not only do I think that's impeachable, but I think it would be essential to being able to uphold Congress's power to engage in an impeachment process. The president should not be able unilaterally to prevent the committee from getting the information. But there's some procedural steps that have to be jumped through, and the House of Representatives was just uninterested in any of that. I personally believe it's just a political view, but I don't think they were really interested in impeaching and removing Donald Trump. I think they were interested in sending out campaign statements that would hurt him for re-election, and I don't think that's what impeachment is for. Second category is the first article of impeachment in the first matter, where although it has to be, this is the abuse of office in connection with his telephone call to the president of Ukraine. I do think we need to be careful about what we say is wrong with this. I think there were a lot of sort of overblown statements, but at the heart of this is something conduct that was really quite un-Republican, small r, and illegitimate. That is, Congress had appropriated funds to the Ukraine for their military protection. The president, if you interpret the facts as the House did, and I'm willing to do that for purposes of discussing impeachability and the nature of the charges, and they may be right too. So what the president did was that he threatened to withhold, not to spend appropriated funds. That's in itself an abuse of power, although one that his predecessor and successor have also engaged in. But the thing that made it a kind of deep dyed problem is that he did it in order to get a foreign country to investigate his political opponent. Now, I believe, I'm old-fashioned, I think that using any governmental power to investigate your political opponents is something that is very serious and only should be done under, for very good reasons and in a quite transparent way, because I think therein lies banana republic land. But to get a foreign country to do it is even worse, and even worse than that, what he asked Zelensky to do is to publicly announce an investigation of Hunter Biden. Trump didn't actually want an investigation of whether Hunter Biden had violated whatever it was. He wanted an announcement of an investigation so that and in this country, when people are being investigated for crimes, the correct norm, violated frequently, the correct norm is law enforcement does not make a public announcement of it, because they may be the presumption of innocence suggest we should not have public opprobrium for people at that state. So that's what Trump wanted. So that's the second thing that makes this so wrong. And then thirdly, just icing on the cake, not the most serious part of it, but icing on the cake, he wanted this to be run through his personal lawyer rather than through proper legal and diplomatic channels. The personal lawyer of the president should never be involved in the investigation of his political opponents. So all of that, to my mind, makes this an impeachable offense. I don't have any problem with that. And I certainly understand why senators also voted to remove on the basis. I think that is serious enough. But I also do think I understand why some responsible senators could vote the other way. Most importantly, none of this came to anything. It was Trump talking in one phone call, and it doesn't speak well of the gentleman, but Trump is the sort of person who just says stuff, kind of, and there's some evidence that the Ukrainians didn't even understand what he was asking and didn't realize that their funds were being held up, and that the whole thing was really just who knows what it was. But also, it is pretty clear that other presidents have threatened not to give people, especially foreign governments, money that they're entitled to in order to do things that seem pretty political. I don't know the facts, but it does appear that Vice President Biden may have done precisely that in trying to get the Ukrainians to fire the prosecutor who may or may not have been investigating his son. I don't know the facts of that, but oddly, we've never really looked into it. I'd kind of be curious to know. Maybe historians in 100 years will think that question is important enough to.
Well, it looks like we have lost Professor McConnell. So hopefully he can join us again and we can hear the rest of his remarks. But while he is trying to log back in, let's go ahead and turn it to Professor Shaw for our last panelist.
Okay, sure. I'm happy to go next and delighted to be here. And I'm also happy to be bumped if Professor McConnell gets back online and you want to interrupt my remarks. I'm happy to do that. So you just let me know and I'll take your lead. But in terms of my remarks, I'm actually going to focus on impeachment defenses. And I'd like to do that in a way that spans both the first and the second. Oh, Professor McConnell's back. So maybe I'll pause there and let you finish your remarks.
I'll try to be very brief.
No, of course.
The third category, I think, is not. The third category is the second impeachment. And I think what happened there was not only impeachable, but I actually don't think highly of the senators who voted to acquit. The only excuse they might have is just how poorly drafted the article of impeachment was. It was a mess. I could talk about that for some time, but they, instead of drafting a a coherent document laying out, a serious case, they toss out words like incitement and insurrection, which practically invite controversy, give Republican senators an out. They should have sat down with sober-minded, maybe even Republican-inclined, serious lawyers and drafted an impeachment article that would have been as hard as humanly possible for Republicans to vote no on. Instead, it's just it's Democratic talking points. And so insurrection is in the title, and then there's no, in the article, there's actually no further mention of it. I mean, it's like, this is if this is a law school exercise in drawing up impeachment articles, I'd have given it a D. Now I'm done.
All right. There's a place to end on. Okay, Professor Shaw.
Sure thing. And I'm now desperately curious what Professor McConnell would have actually drafted in the impeachment article. So maybe we'll have a chance to get to that in the Q&A if there's time. But so I will be brief, or I'll attempt to be brief, and focus my remarks on impeachment defenses. So basically, what kind of arguments get offered by individuals facing impeachment? Well, one has already been alluded to, right? Virtually every official who has faced impeachment has offered the argument that impeachment is limited to chargeable crimes. And I'm not sure if anyone has ever really improved on Charles Black's dismissal in 1974 of that argument, but he wrote that it was just not remotely possible that this interpretation is right. So whatever the sort of category of offenses properly subject to impeachment looks like, and whatever the contours are, it must be that some non-criminal conduct is impeachable. And that has to be especially true in the context of the president, right? So presidential misconduct may not violate a criminal statute, potentially because it is the kind of conduct that can only be engaged in because of the president, because related to the particular powers of the office, right? Imagine using a position as commander-in-chief to order an attack on the United States because of, switched allegiance to a foreign power. Or it may be the kind of conduct that is just not criminal on any conception of the criminal law, but would nevertheless constitute serious enough misconduct or abuse or dereliction, which is not to say maladministration, but dereliction, if engaged in by the president, that impeachment has to be available, right? Imagine, to vary one of Charles Black's examples, the president simply taking a permanent vacation, just refusing to show up to work, within the first year of a 4-year term. It cannot be that election is the only thing that can remove a president from office, though taking a vacation is obviously not a crime. So that, I think, is a defense that has been offered, and despite its broad rejection, I think, by most people who have thought seriously about impeachment, continues to rear its head. But I actually want to focus instead on two defenses that were raised in different ways in the two Trump impeachments. One, defenses that sound in the First Amendment, right? That is where impeachment is predicated in whole or in part on speech, and where the official facing impeachment argues that that speech is protected by the First Amendment. And then second, defenses that cast the speech or conduct that is subject to impeachment as merely permissible political activity. And I think that overlaps with, but it's not identical to, the First Amendment defenses. So I want to ask about how we should think about these defenses in relation to courts' consideration of similar or identical sorts of arguments, and also how we should think about them independently of the way courts consider these kinds of arguments. And, I think that there is sort of a threshold issue maybe to take a beat on, which is whenever you spend any time with historical impeachments, or at least when I've spent time with historical impeachments, it quickly becomes clear that the kind of precedential force or value of any particular impeachment or any aspect of a prior impeachment is a difficult and sort of underexplored question, right? And that's, of course, one of the reasons for this convening, as I understand it, to try to make sense of the two Trump impeachments, in part for what they tell us about the role of impeachment in the constitutional order, and also because they are now part of the body of impeachment precedent. So trying to figure out what they stand for could matter a great deal in terms of future impeachment efforts. Now, how they will matter isn't self-evident, right? So, even if any particular impeachment episode revealed clear consensus in Congress about the proper objects of impeachment, right? Like if we had, if we ever did have a conviction of a president by an overwhelming majority, or a conviction at all, or acquittal accompanied by statements that, sort of one after another essentially uniformly pointed to an identical flaw in the impeachment case or charge, it is still not clear that that sort of precedent would bind any future Congress in the same way a precedent of the Supreme Court presumptively binds a future Supreme Court. But that would be powerful, even if not binding impeachment precedent. But that's obviously a purely hypothetical scenario. Impeachment history, including the history of the Trump impeachments, is complex. It is contested. Each presidential impeachment episode reflects a sharp division between House and Senate, a degree of internal division within each chamber. And just as each impeachment means and represents something much more complex than a binary conception in which impeachment, if it results in acquittal, must be a complete exoneration of the impeached party. And if it results in conviction, again, if that were ever to happen with the president, that would necessarily represent an approval of the case in toto. But I think sort of appreciating this complexity of sort of the law of impeachment and impeachment precedent, it seems to me useful to try to press on what different aspects of each impeachment episode contribute to impeachment precedent and to the law of impeachment. And of course, this is the law of impeachment, right? These episodes are all the law we have. The Supreme Court told us in the Walter Nixon versus United States case that at least challenges to impeachment procedures present non-justiciable political questions. And whether you view that case as holding really broadly that all questions related to impeachment procedure are fundamentally not suitable for judicial resolution, or whether you take a more kind of Souter in his concurrence view that some types of procedural decisions, right, flipping a coin or impeaching for being a bad guy, those kinds of things could potentially be properly challenged in and resolved by courts. Either way, what we have right now, impeachment precedent and practice, are all we've got, right, because the courts haven't weighed in at all. And that's, I think, relevant to sort of the point that I'm going to make about the overly judicialization, I think, of some of the arguments, and in particular, the First Amendment arguments that were deployed in the Trump impeachment in particular. And the key First Amendment argument is, of course, just raised in the second Trump impeachment, and maybe I'll start there. It wasn't really an issue, at least sort of an explicit First Amendment argument, wasn't really an issue in the first Trump impeachment. And that's because, despite early efforts, in particular by Representative Al Green, right, who in 2017 introduced articles of impeachment charging President Trump with supporting white supremacy, bigotry, racism, anti-Semitism, inciting hate and hostility, sowing discord, these kinds of speech and rhetoric grounded charges that, of course, were not approved by the House. So despite those early efforts that might have drawn First Amendment efforts had they been serious, First Amendment defenses rather, had they been seriously pursued, the impeachment actually pursued in 2019 and early 2020 obviously centered rather narrowly on President Trump's dealings with Ukrainian President Zelensky. But in terms of the second impeachment, speech was obviously front and center, right? So the single article of impeachment that Professor McConnell was obviously just critiquing charged Trump with incitement of insurrection based in significant part on his speech at the rally at the Ellipse on January 6th. Right, of course, during that speech, as I'm sure people are aware, he repeated false claims that we won this election, we won it by a landslide, told the assembled crowd, if you don't fight like hell, you're not going to have a country anymore. All of this is quoted in the article of impeachment. And we should say this is not the first presidential impeachment article that was predicated in part or in full on presidential speech, right? So the first presidential impeachment of President Andrew Johnson in 1868, despite focusing primarily, right, in 10 of the 11 articles of impeachment on President Johnson's violation of the Tenure of Office Act and his firing of War Secretary Stanton without obtaining Senate approval, also contained an article that was purely about Johnson's speech, right? Not related to the tenure of office article at all. So that's the 10th article that, charging that President Johnson made intemperate, inflammatory, scandalous harangues, uttered loud threats and bitter menaces against Congress. The 11th article, although it is about the Tenure of Office Act, actually sort of references speech as well. Johnson had attacked his adversaries in Congress on a number of occasions, including once, although in a speech that's not cited in the article, asking an assembled crowd, why don't you hang Thaddeus Stevens and Wendell Phillips, who were, radical Republicans and two of his chief congressional antagonists. And interestingly, despite the fact that obviously understandings of the First Amendment's reach were far more circumscribed in 1868 than they are today, Johnson's attorneys did invoke the First Amendment, although really in passing and not particularly developed arguments. So Ben Curtis, one of Johnson's attorneys, asked in his opening remarks, who is to be the judge of whether he speaks properly? But the First Amendment argument, again, wasn't particularly developed. Now, the Senate, which of course acquitted Johnson by a single vote on several articles of impeachment, never took a vote on the 10th article. So, in terms of impeachment precedent, it's hard to know what to make of this historical episode. There's no definitive statement about how the argument was received. There were several written statements that are in the record by senators who did clearly harbor some concerns about imposing the punishment of impeachment for speech. And I should say the 10th article, it's sort of a historical footnote, although I do think that Brenda Wineapple, who was on a panel yesterday, really sort of has restored that article to a more central place in, I think, discussions of the Johnson impeachment. And I think that's part of an effort, I think, to tell a very different sort of version of the story of Johnson's impeachment than Professor McConnell was just alluding to, which is to say, for a long time, I think the big lesson of the Johnson impeachment was one of partisan overreach and of sort of, courageous defection on the part of Senator Ross, who cast the sort of decisive vote to acquit. And that's obviously partially because of JFK's Profiles in Courage chapter about Ross. And yet there's a much more complicated story in which, even if poorly executed or drafted in certain respects, the Johnson impeachment effort was actually a righteous one that really was about Johnson's efforts to thwart a reconstruction and a multiracial democracy, rather than for having stepped on the statute, I think, as sort of the classic attack on the impeachment effort is often framed. But in any event, so there is a First Amendment defense to these subsidiary, but I think maybe not so subsidiary as we once thought, aspects of the Johnson impeachment charges. We then have the Nixon impeachment, in which Nixon's resignation obviously forecloses the possibility of full impeachment proceedings, but the Judiciary Committee had, at the time of the resignation, approved 3 articles, and one did focus on presidential statements, so presidential lies made as part of a campaign to obstruct the investigation of the Watergate break-in are expressly referenced in that first article of impeachment. Making false or misleading public statements is also expressly contained within the impeachment article. And interestingly, after the release of the smoking gun Oval Office tapes, a number of Republican congressmen who had initially voted against the articles in committee then released public statements indicating that they had come to support at least the first article of impeachment, right, the obstruction of justice charge, and the one that relied the most heavily on the president's speech. Interesting, because at least some of those members indicated that they would not support the other articles, but that they did support this one. So again, figuring out what precedential value these individual episodes within any impeachment saga kind of represent is, I think, a difficult effort, but one that is sort of worth engaging in. And I think we know that history is an important part of, in fact, it's sort of all we have when we're thinking about impeachment. But again, the sort of the precedential effect, if any, of these episodes is, I think, sort of underdeveloped. But it seems to me meaningful that there are, written endorsements of the position that the first impeachment article, again, with its sort of central focus on the president's lies and public statements, at least is a significant aspect of the early steps toward impeaching President Nixon. And I think you can contrast that with the congressional treatment of President Clinton's public lies and speech during the impeachment proceedings against him. And sort of, if you dig into the legislative record, in addition to the articles that charged perjury and obstruction of justice that were ultimately approved by the House, the House Judiciary Committee, considering the Clinton articles, actually initially debated a draft article that tracked something that was in Starr's impeachment report, or Starr's Starr report. So that draft article was captioned abuse of power, and it was largely concerned with Clinton's public-facing statements, right? So it charged the president with making false and misleading public statements for the purpose of deceiving the people of the United States, to conceal his misconduct. So it was all about public speech, public lies. And an amendment in committee was introduced to remove that language, the language about public lies and public speech. The committee, of course, did go on to approve other articles, but then didn't approve this speech grounded article at all. And there are a bunch of statements in the committee report basically taking the position that lies to conceal personal misconduct are not an appropriate subject of impeachment, even if lies in other contexts, right, presidential lies, might properly be subject to impeachment. So all of this, I think, is really important, interesting history. None of it figured particularly prominently in the impeachment case against President Trump, and in particular, sort of the speech grounded case. And very interestingly, I thought the impeachment managers sort of took the position. So Trump argued early on that I'm being impeached for my speech, and that's a First Amendment problem. And in response, the managers argued that the First Amendment, basically had no role to play at all in impeachment. That, to quote from their trial brief, the First Amendment protects private citizens from the government. It does not protect government officials from accountability for their own abuse in office. And went on to argue that the First Amendment does not apply at all in an impeachment proceeding. And while I think it's certainly right that judicial formulations of the First Amendment, right, which were what Trump was relying upon, right? He said, I'm being charged with incitement, and my speech could not possibly satisfy the judicially enunciated Brandenburg test. Therefore, I must be acquitted. And it just seems to me to mistake the role of judicially announced standards in impeachment proceedings. They're just not, I don't think, relevant. In some ways, this is a species of the argument that impeachment must sort of track chargeable crimes. Impeachment charges must, because there's this sort of importation of these criminal defense standards, right? So Brandenburg is a First Amendment defense against a criminal charge. But because there's no criminal charge required, I'm not sure the criminal defense standard is in fact a relevant one. And so I think both Trump, in the defense that he offered, the First Amendment defense, and in some ways the response to that defense, both the anticipatory response and the response that followed the actual making of these arguments, lean too heavily, one, lean too heavily on courts, or two, suggested the First Amendment because, the First Amendment entered the discussion in this sort of judicial clothing that it was off limits altogether. But I think rather, of course, the First Amendment applies because it's a constitutional process and the First Amendment isn't suspended, but that the Senate itself in the course of the trial was in the best position to decide how, if at all, the First Amendment interest would bear on so I'm hearing some interference, would bear on the decision that would bear on their analysis of the propriety of convicting for this kind of speech-based misconduct. And I see I'm short on time, so maybe I was going to say a couple of words about sort of the defenses to the first impeachment, which were largely that this was simply political misconduct. And in some ways, this ties up a little bit to something Professor McConnell said at the end, which was the idea of using government resources for personal political advantage. Trump said in his trial brief, there's nothing wrong with that politicians always act in part out of political motive or desire to advance political self-interest. And in some ways, when Trump's lawyers made those arguments, they didn't explicitly cite Supreme Court precedent in the same way as they did in raising the First Amendment defense in the second impeachment trial. But I actually think a lot of that drew more subtly on Supreme Court precedent, cases like Citizens United, United States versus McDonnell, right, the Virginia Governor McDonnell, sort of suggesting that there are real limits in the law's ability to reach or to control, for different reasons. First Amendment on the one hand, sort of vagueness concerns on the other, but to reach the practice of politics, even if sort of unsavory. And I think that you sort of saw the logic of those cases migrate into the halls of the Senate or in the House as well, in the way that President Trump framed those kinds of defenses. So there's more to say, but I'll stop there. Thank you so much.
All right, thank you to each of our panelists for those comments. What I'd like to do now is open it up to the audience for questions. And so if you have a question, feel free to submit that. And I will start by asking my own. And if each of you don't mind just taking a kind of concise stab at this. But the question for the panel is, what is an impeachable offense? And what I heard from each of you in different ways is that an impeachable offense is not limited merely to things that are criminal or criminally indictable, but also that it's not merely political, that it's not a kind of prime ministerial system where the president serves at the pleasure of Congress, but that there's some ground in between where Congress has to make a judgment constitutionally about what counts as an impeachable offense. And we have this language in the Constitution in Article 2, which just says other high crimes and misdemeanors. And so we know treason and bribery, and then we get other high crimes and misdemeanors. And so the question to each of you is, how do you understand that phrase, high crimes and misdemeanors? And if it is implausible that it actually means something that's merely criminal, why is that implausible? And how should we interpret or understand what it's actually trying to get at? And just a kind of concise answer to that. And Professor Whittington, I'll come back to you since you started our panel.
Yeah, so let me start just by saying I agree with Michael completely on the fact that we not only want to draw a boundary on one end of saying this can't be limited to criminal offenses, but likewise on the other end, we need to be able to say it can't be reduced down to mere political disagreements and policy disagreements. It's clear that's not what the founders wanted. I don't think it's consistent with the larger structure and purpose of what the impeachment power is for. And so you're somewhere in the middle. And unfortunately, the middle is mushy. I think hard to determine, right? I think there's going to be a very blurry line when we come, especially trying to distinguish between what counts as a mere political and policy disagreement on the one hand from a genuine abuse of power. So even if we take the example that was raised earlier by Kate of thinking about, well, what if that Black raises, and when he talked about impeachment, what if the president just goes on permanent vacation and doesn't do his job, right? That kind of negligence, which negligence comes up in the context of the second Trump impeachment as well, right? That kind of negligence in conducting your duties is something the founders are worried about, and they think it's part of what you ought to incorporate within impeachable offenses. But ultimately, it requires political judgment to know when have you crossed the line from you're just on vacation to wait, it's like your vacation's gone too long, or you're just conducting your duties, but now you've made some really bad choices about how to conduct your duties, such you're leaving the laws insufficiently executed. And I don't think we can avoid that fact. At the end of the day, there have to be some political judgments exercised, while also cautioning Congress that likewise is an abuse of the impeachment power if they simply want to make impeachable ordinary political disagreements and policy disagreements.
All right. Either Professor McConnell or Professor Shaw want to take a stab at that question? I think you may be muted.
Muted, sorry.
There you are.
Here I am. I guess we need another 2 years of COVID to teach me how to unmute. The term high crimes and misdemeanors comes into the Constitution kind of mysteriously. It was not the language of any of the state constitutions. At this point, the delegates had rejected like about 8 different formulations: maladministration, corruption, neglect of but they'd just sort of gone through them all, and they didn't like any of them. It was like Goldilocks, some are too strong. And then George Mason, who had just proposed maladministration and withdrew it, then sort of pulls high crimes and misdemeanors out of his back pocket, and it's adopted without any discussion, explanation, debate whatsoever. So we actually are pretty bereft of direct information. It does come from British practice, but it seemed just to be the label that the House of Commons slapped on whatever it was impeaching people for, and they impeached people for anything they wanted to. And the most recent ministerial impeachment, not the Hastings, but the last impeachment of an actual officer of the Crown, the impeachable offense was negotiating a bad treaty. So who knows?
All right. Professor Shaw.
Well, I feel a little self-conscious doing this as a non-originalist on this panel, but I do think Hamilton's Federalist 65 actually probably does as good a job as any of sort of encapsulating what is actually intended by this language, high crimes and misdemeanors, which is, offenses that are in their nature political, right? That sort of relate to injuries to society itself. So I think that and those, again, may or may not be indictable or chargeable crimes, but that where the offense is to society, to the constitutional or political order, that those actions that are properly subject to impeachment all share that basic quality.
All right. And while I have you, I have a question for you, actually, Professor Shaw, from one of our audience members. The question comes from Betsy Smith, who's a JD candidate at the University of Missouri School of Law. And the question is, she asks, as law students, we focus on precedent and the importance of precedent. Can you tell us more about how the little precedent on impeachment has affected your studies and your view of the Trump impeachment?
Sure. Yeah. I mean, I do think that what's tricky about studying impeachment is, I think for law students and to a degree law professors as well, is it's a different body of precedent. There are no judicial opinions that deal substantively with what is a high crime and misdemeanor and what procedures, may either the House or the Senate constitutionally adopt in charging and trying impeachments. But I think that in the same way, it would be, pretty incomplete to simply sort of read the holdings, sort of the kind of identify the winner and the loser of any Supreme Court case and sort of decide that you have understood what the case stands for, it is obviously also incomplete to simply say that, every president to have been actually charged and tried has been acquitted. Of course, Nixon is the sort of complicating counterfactual because everyone assumes, and I think this is probably right, that he would have been convicted had he remained in office. But that's a functioning of the system in a way as well. But I do think that I don't have an answer, but I do think it's an important question that we do need. And we've of course been all reading this history, but figuring out what lessons to take from, what to sort of understand the history as standing for with respect to each of these impeachments is a very important undertaking. And just as Professor Victoria Norse, who's I think on the next panel, talks about the only way to really understand the output of the legislative process, right, to interpret statutes properly is to read. She sort of discards the term legislative history, which is of course a freighted and divisive category, and she calls it legislative evidence, right? Let's look at the way Congress actually works and passes statutes, and that'll help us understand, how properly to interpret the handiwork of Congress. And in some ways, I think that's what I'm suggesting we need to do, is to both study the underlying events. And again, this is not novel. This is, historians have been doing this, as have law professors. But I think to think of it in terms of impeachment precedent and the law of impeachment might be a slightly different kind of frame. And so to kind of understand that they're not going to be neat lessons or takeaways, but that we can make arguments marshaling this kind of evidence in these episodes about how we should understand the consensus and the disagreement that existed within each body and sort of, outside of the halls of Congress more broadly. I think those are all really important sort of efforts in understanding how impeachment is going to function kind of going forward.
Thank you. I've got some snow removal going on outside of my office. So if you hear that in the background, that's what that is. We have another question, and this question reminds me in some ways, Professor McConnell, of your comment about the House being able to impeach, being able in the sense of physically possible for them to impeach for somebody squashing a bug on the sidewalk. And it's a question about the burden of proof in an impeachment trial, and that may just be the answer, is it could in some sense be arbitrary, even though they should not impeach for certain offenses. But the question comes from Grace Hambuchen from Mizzou Law, who's a 3L, and I apologize, Grace, if I mispronounce your last name. And she writes, this might have a simple answer, but what is the burden of proof in an impeachment trial? What impact does it have on an impeachment case? What constitutes an impeachable offense? So how tied is the political process to this constitutional understanding of what constitutes an impeachable offense? That's a question for the panel generally, but feel free to jump in if anyone would like to take that.
So I guess I started. I just note that the question of what counts as burden of proof has been contested over impeachments over time. This is something that gets raised. It has never been clearly settled. So it's actually not a question with an easy answer. Senators disagree among themselves across different impeachments as to what the right burden of proof is. And thinking about it, unsurprisingly, those who are targets of impeachments want to set the burden as high as possible. The House tends to want to argue that the burden ought to be quite low. And moreover, it has two implications in two different contexts, because, of course, the senators and how they serve in the impeachments are not strictly speaking jurors as such, but they're also judges, and they're trying to think about what the legal standard here is. It's sometimes the case that the facts are seriously disputed in impeachment context. And one thing the senators are trying to figure out is, are we convinced that this actually happened in the way that the House laid out? And there, I think the standards often are sort of framed more higher. The senators want to be quite convinced, maybe something like it beyond a reasonable doubt, that this actually happened the way the House is describing when they're prosecuting the case. On the other hand, the question of how persuaded do we have to be about the nature of the offense and whether or not it's an impeachable offense, I think the standard there is a little lower, where there's more of a sense of, yeah, it may be debatable and arguable, and people disagree about whether or not that's an impeachable offense, but there's not a sense of everybody absolutely has to be on the same page, or you shouldn't regard it as an impeachable offense at all. And so it depends a little bit on what questions senators are trying to ask as to how they think about how convinced do I need to be before I can pull the trigger on this.
All right, thanks. This last question gets into where you just left off about what the members of the House and the members of the Senate ultimately will be doing and making judgments how they should go about that. And so we have just a few minutes left, and Professor McConnell, I'll ask this question to you. It comes from Noelle Mack, 2L law student at Mizzou Law. And she writes, if legal scholars can't widely agree on what constitutes an impeachable offense, how should politicians manage bringing impeachment charges given the current political climate and likely public backlash?
Well, legal scholars actually, I think, are much closer in agreement than the question suggests. I mean, there are some outliers, but if Kate and Keith and I are in kind of the same ballpark, I think that actually is evidence that there is a kind of consensus out there among legal scholars. I think the real problem, there's so many problems with the hyperpolarization of our culture and Congress too. But as it manifests itself in the impeachment area, I think we might well find ourselves exactly where Hamilton warned that we shouldn't be, where he warns. I wish I had the quote memorized, but he's about a factious group in the House, using impeachment as nothing but a political tool. Now, by the way, he's not focusing. The reason he focuses on the House is just that they're the ones who do the impeachment. But faction, the idea of faction being the problem here, I think, is key. And unfortunately, impeachments tend to be extremely partisan, which would be our way of talking about factions. And if there were a way forward, and I'm not sure that there is, but if there were, it would involve something like what happened in the Nixon impeachment, where people of both parties actually had something of an open mind, and they considered the evidence. They did not rush to judgment. People changed their minds during the course of the proceeding. The Democrats who were in charge were extremely respectful of the Republicans, giving them every chance. It was a fair process. And in the end, the only impeachment, I think, in American, it didn't end up in an impeachment because Nixon was going to be convicted, but it was really the only one in American history that worked. Let's return to that.
All right. Thank you for that thought. We have just a couple of minutes, and we were chatting just on the side about concluding thoughts. And Professor Whittington brought up one, and I'll let you share this in terms of the polarization and partisanship with respect to these various impeachment proceedings.
Yeah, I would just say I think polarization is an extraordinary challenge when we're thinking about presidential impeachments. It clearly would be if we were actually to impeach cabinet officers, which Congress has rarely done for a variety of reasons. But most judicial impeachments, it's worth highlighting, have not been so partisan and so polarized. And I think there's some reason for optimism that it would still be the case. There could be impeachments in the near future of trial courts or even circuit court judges that would feel much more routine in that sense and not spur this same kind of partisan disagreement that we see in the presidential context. I do think in the presidential context, though, and it goes back to something Michael said very early on, there's a real responsibility to try to reach across the aisle, try to make appeals that could work with the other side. If for no other reason, then certainly you need that in order to get a Senate conviction. And moreover, if you don't want it to backlash on you and you want to be able to establish a set of norms going forward, you need some buy-in from the other side. So you ought to be trying to make that pitch.
All right. Well, thank you for that concluding thought. And as I was listening to you and learning from you in the panel today, I was thinking about the way in which this process requires, as several times was mentioned, that members, these politicians, have to swear an oath as they go into the impeachment proceedings. And part of that oath seems to be a suggestion constitutionally that they set aside, for that moment at least, their partisan attachments, and they have to reason on a higher plane about constitutionalism and constitutional norms. And there's a reason why this process is not legal. It's not a legalized process, but it's legislative, and the legislature then convenes and operates in this mode to conduct the impeachment trials. And so we have to reason together about this constitutional process, and I think you have all shown us very well how we could do that. So we appreciate you being here with us today and sharing your thoughts for this 2022 symposium on the 2 impeachments of Donald J. Trump. Thank you.
Okay, good morning, everybody. Let me just make sure we have all of our panelists here. Do we have everybody? Brian, Philip, Victoria? Terrific. Good morning to all of you. And good morning to those of you in the audience. My name is Tommy Bennett. I'm an associate professor here at the University of Missouri School of Law, and I'm delighted to be taking part in this excellent symposium that's been going on already for the better part of a day here. So our task today in this third panel of the symposium is to address two questions about the second Trump impeachment, the more recent of the two. And the first question is, what purpose does impeachment serve if the Senate does not convict? The second question we've been charged with answering is whether impeachment should even be attempted if there's no real possibility of conviction. So we're very lucky today to have three distinguished scholars of impeachment and constitutional law to help us answer those questions. From the Michigan State University College of Law, we have Brian Kalt. From Columbia University and the University of Texas at Austin, we have Philip Bobbitt. And from Georgetown University, we have Victoria Norst. So each panelist will in turn have a chance to provide their thoughts on those two questions that we've been charged with answering. And then we'll have some time to discuss amongst us as a panel any points of interest or disagreement or convergence among the various panelists. And of course, at the end, we'll be sure to leave some time for audience questions. So be thinking in advance about what you might like to know from our esteemed panelists. We'll go in the order on which the names were listed on the schedule, which will start us with Professor Kalt. Brian Kalt is a professor of law and Harold Norris faculty scholar at the Michigan State University College of Law. He teaches courses in administrative law, torts, constitutional law. He's written 3 books, including most recently 2 books that cast new light on procedures for removing presidents from office. Professor Kalt is also the author of dozens of law review articles on such varied topics as presidential appointments, election recounts, constitutional dimensions of criminal trials, and of course, how to get away with murder. His work on so-called late impeachments was cited by both sides in the most recent impeachment trial. Welcome, Professor Kalt, and we'll begin with your comments.
Well, thank you for that introduction, and I'm thrilled to be here on this panel with 2 scholars whose work I have been a lot for a long time, have cited often as well. So what purpose do impeachments serve if the Senate doesn't convict? Should impeachment be attempted at all if there's no chance of conviction? These questions remind me of the old joke in which someone is asked whether he believes in infant baptism. And he replies, believe in it? Heck, I've actually seen it done. I'm not a fan of failed or futile impeachments. Nevertheless, I've seen them done 3 times now. And so while I have some not particularly edifying thoughts about them, and I will be sharing those, I don't think we can simply write them off. I think we need to try to draw some larger lessons, and I'll try to do that as I answer our 2 questions. And I'll conclude with my suggestion for how to take the impulses that drive futile impeachment and transfer them into something more functional. And just to get this caveat out now, I'm only going to be talking about presidential impeachments. So what purpose do unsuccessful impeachments serve? To answer that, I think we have to begin by asking a more general question. What purpose is any impeachment supposed to serve? We heard earlier from Keith Whittington, who answered that question. What I say will overlap a bit with that. Interestingly, the debate over the unusual timing of the second Trump impeachment turned on that same question. To those who believe that Trump couldn't be tried because he had already left office, the essential purpose, the sine qua non of the impeachment process, is to remove the offender from office. Those like me who believe that late impeachment is constitutional freely concede that removal is the most important function of the process writ large, but that doesn't make it the sole function. And there's plenty of evidence from text and history and structure and precedent of multiple other purposes. First and foremost, in Trump's case, obviously, was disqualification from future office. But regardless of whether you think impeachment is only about removal or you think it's also about disqualification, neither one of those consequences can apply if the Senate acquits. And as as we saw, they did. Those goals weren't achieved. But as Keith Whittington laid out earlier this morning, the impeachment process was designed with still other purposes in mind. One of them is deterrence and shaping norms, very important. Only 3 presidents have been impeached, but the possibility of impeachment hangs over every president's head, and it restricts every president's actions. Whatever bad things presidents have done over the centuries, you can surely imagine many of them doing much worse things had they been guaranteed a full 4-year term with no possibility of immediate accountability. And allowing late impeachment extends that deterrent effect to the very end of the president's term. But acquittal can undermine that deterrent effect. It doesn't always, as we've seen discussed earlier. Andrew Johnson was chastened by his impeachment ordeal. But that was only because conviction was a very real possibility for him. It was probably only by making concessions to the opposition, concessions that reinforced or reestablished important norms at the time about the relative powers of the president and Congress. It was only by making those concessions that he avoided conviction. By contrast, though, Presidents Clinton and Trump had enough support in the Senate that it became apparent pretty soon in each of their cases that they'd be acquitted. And the result of that was, at best, a dulling of any deterrent effect, and to some extent a reversal of them, as Michael McConnell discussed earlier today. It was only natural for Clinton and Trump to take their acquittals as victories, and Trump in particular emerged decidedly unchastened. One last purpose of impeachment that I'll mention is to investigate and to publicize the president's conduct. The investigative function, though, has weakened greatly since Nixon's day. What the House committee did then versus what the House has done since then, how much they farmed it out to independent counsels, has changed a lot. So we've seen that investigative function weaken. But the publicization function still looms very large. Impeachment trials provide a forum, not just a verdict. And they shine a light on a president's conduct in a way that nothing else really can. Both because the Senate trial is harder legally for a president to brush off, the way he might brush off other forms of oversight, and because the trial provides a unique spectacle that captures the nation's attention in a very distinctive way. But in an environment of hyper-polarized partisan politics, this publicization is a double-edged sword. Impeachment can expose a president's misdeeds to a wide audience, but as Keith Whittington suggested just earlier today, it can also provide the president with an equal time platform to rally his own supporters behind his counter narratives and actually solidify his political standing within his party. Contemplating this effect of strengthening the president's standing within his own party, I wrote after the first impeachment proponents might find this unfathomable, but their incredulity will not move the political needle. So in sum, impeachment serves a limited purpose when the target is acquitted. And if the president retains enough support from his own party that he's easily acquitted, it might not serve even that limited purpose. So that takes us to our second question. Should a president's opponents ever pursue an impeachment that they know won't yield a conviction? If you think the president has committed so grave an offense that he deserves to be removed and disqualified, why pursue a course of action that not only won't remove him and won't disqualify him, but will rally his half of the electorate and hand them a victory? My answer is you shouldn't. That futile impeachments serve no good purpose. And yet, they happen. Now, to be fair, I don't think that the second Trump impeachment is the best example of this phenomenon. Democrats had reason to think at the outset that they could get a conviction. And by the time it became clear that they wouldn't, I think they'd come too far to simply give up. President Clinton's impeachment though, and the first Trump impeachment were more obviously doomed from the start. Still, the leaders pushing those impeachments thought that they were accomplishing something. They had what they thought was a good purpose from their political perspective. And as elected officials, it is they, not random law professors, who decide what should or shouldn't be done with impeachment. This underscores the political half of the law and politics strange hybrid that is impeachment. And the political component of impeachment has changed a lot over the centuries. Whatever frequency the framers expected impeachment would be seen with, the 2/3 majority requirement for conviction in the Senate has made consensus the defining feature of presidential impeachment. And that used to make presidential impeachment rare. Andrew Johnson faced the only Senate in American history in which the opposition party had a 2/3 majority. Indeed, they had an 80% majority. That's consensus. Richard Nixon resigned when he saw the impeachment handwriting on the wall, with sufficient numbers of his own party senators poised to vote to remove him. Again, consensus. But the upsurge in partisan polarization we've seen in recent decades has changed that calculus entirely. Back in Nixon's day, and for some time before that, there was an ideological middle in Congress. Both parties had some members on the other side of that middle, and now there's a big empty gap in the middle. In all but the most evenly divided of houses, the dominant party can attain a simple majority and thus impeach without attracting the support of ideological moderates. But on the Senate side, that polarization has the opposite effect because it requires 2/3. It requires significant support from members of the president's own party, and that means the opposition's fervent partisan warriors have to leap over that empty middle and attract a significant number of the equally fervent warriors all the way over on the other partisan pole. And because our two-party system has lately become something more like a two-reality system, the bar is raised even higher. To achieve the consensus needed for a conviction when we have alternate versions of reality at play here, it's much harder. But at the same time, that split reality makes it harder for impeachment proponents to see that their case is doomed. How could they not vote with us, they might think? Because in reality, they think it's clear. Their reality is not the opposition's reality. And the result is that it's become much easier to find a House willing to impeach at the exact same time that it's become much harder to find a Senate willing to convict. And so we've seen this rise of futile impeachment. After having just 2 impeachment efforts, both of them with serious probabilities of success, Johnson and Nixon, during the first 41 presidencies, we saw 3 impeachments, each falling well short of conviction in just the next 4 presidencies. Going from 2 out of 41 to 3 out of 4 is a remarkable transformation. So what's the payoff for those who pursue futile impeachments? First, again, it bears repeating that proponents might not grasp that they're going to lose. It's hard to admit to yourself that you're going to lose. It's hard to give up when you know you're right, especially when you think that being wrong poses a clear and present danger to the republic. You'll want to take the strongest action that Congress can take against a president, declare his conduct to be unacceptable, render it infamous. But again, the simple fact is that an acquittal means that the president is not held accountable. He suffers no legal consequences. And that was certainly true in the second Trump impeachment. Rather than unite the country against Trump, the impeachment solidified the deep divisions currently cleaving the country. When push came to shove, most Republicans rallied around Trump, and we've seen those few who didn't have suffered greatly for it politically. So what do we do? Well, my own preference is censure, which we heard Peter Baker discuss yesterday. Speaker Pelosi, and she's the speaker, she feels very strongly to the contrary. When she was asked about censure after Trump's second acquittal, she complained that censure, quote, lets everybody off the hook, unquote, and that it would only be, quote, a little slap on the wrist, unquote. So she dismissed it on those grounds. But when Trump was acquitted, he was let off the hook without even a little slap on the wrist. Now, clearly, censure is an inferior remedy to conviction, but censure will often be better than an acquittal. And Trump's acquittal was much less consequential than censure would have been. A successful concurrent resolution of censure would have been a loss for Trump, not a victory like his acquittal was. And while it would have had no legal effect, if it did, that would probably make it unconstitutional, censure would have had a profound political effect. Why is that? Well, a common feature of President Clinton's trial and both of President Trump's was senators of the president's party saying some version of what the president did was wrong, but ... And there were multiple buts to choose from in Trump's second trial, most prominently an issue I've specialized in, the timing of the trial. But the point is that it allowed many Republican senators to thread a needle, voting to acquit Trump without having to defend his actual conduct. And a censure debate would have largely removed that option. The only question would have been whether Trump's actions warranted official condemnation. Some Republicans would have condoned his actions, but many more, I think, would have condemned Trump than did in the impeachment trial. And all of them, whether they condemned or condoned him, would have been announcing to the electorate their clear binary choice with nowhere to hide. It also would have been much quicker than impeachment. It would have allowed a vote to be held before he left office, probably, certainly less distanced from the reality of January 6th before we got into the politics of usual as soon as February. And most importantly, because Republican leaders themselves were suggesting a censure resolution, just as Democrats had during the Clinton impeachment, calling that bluff, assuming it wasn't a bluff, and proceeding with censure might have attracted, again, much more Republican support than the 7 votes that the impeachment trial yielded on the Republican side. And that would have produced a much more politically potent expression of condemnation than the acquittal did. So what's Congress to do? When they're faced with a president who's done things that bicameral majorities will condemn, but not a 2/3 majority in the Senate, what should they do? And there are 2 choices. One is to have an impeachment that leads inexorably to an acquittal so that nothing happens to the president. And the other is to censure the president so that he bears the official condemnation of the Congress of the United States. Not just the House, not just the opposition, but Congress itself. I think that's something. As opposed to nothing. And something is better than nothing. And it mattered the 4 times that presidents have been the subject of congressional rebukes like that. I promise you this issue will arise again and again in the years to come because of the dynamics that I've mentioned. And I hope that when it does, future Congresses resist the lure of futile impeachment and pick a more fruitful path.
Thank you very much, Professor Call. Rather than invite comments or questions now, we'll proceed with Professor Bobbitt's comments. And we're very lucky to have Philip Bobbitt here with us today. He's the Herbert Wexler Professor of Federal Jurisprudence at Columbia University, where he also serves as the director of the Center on National Security. And in addition to all of that, he's the distinguished senior lecturer at the University of Texas in Austin. His 10 books span such weighty topics as Machiavelli's constitutional thought, social values and their trade-offs, the war on terror, nuclear strategy, and constitutional interpretation. He's been elected a member of the American Law Institute, the Council on Foreign Relations, and the Royal Historical Society. Last year, Professor Bobbitt was named an honorary Knight Commander of the Order of British Empire by Her Majesty Queen Elizabeth II. In 2018, Professor Bobbitt updated, expanded, and greatly enriched Charles Black's classic text, Impeachment, a Handbook. And during the most recent impeachment process, Professor Bobbitt argued that Congress lacks the power to impeach officials who are no longer in office. Thank you for being here, Professor Bobbitt, and I look forward to your comments.
Thank you for that very generous introduction, and thank you to Brian Colt for such a subtle and, I must say, very persuasive presentation. We are asked, what is impeachment for? I would say it's for punishment and exposure. Donald Trump richly deserved punishment and exposure for his long, unconstitutional campaign to ensure his reelection by discrediting and subverting any electoral results in favor of Joe Biden. I believed, nevertheless, that I wrote that it would be a mistake to hold a second trial of impeachment. After exchanging views with those who disagreed with me, after having watched the proceedings and read views contrary to my own, I came around to a somewhat modified, less categorical position. I still believe that Congress's power to convict a person of an impeachable offense extends only to those persons, all civil officers, and only to those grounds, treason, bribery, and other high crimes and misdemeanors, specified in Article 2. I think the text of the Constitution is definitive on these points. No other provision of the Constitution can be reasonably interpreted to enlarge these powers. But I've been persuaded by members of the Symposium, among others, that the House may impeach and the Senate may try a person who is a civil officer at the time of impeachment, but who, following his lawful impeachment, ceases to be a civil officer. The text can be read without too much main force to reach this conclusion, as Michael McConnell and Frank Bowman have argued. Section 2 of Article 1 provides that the House shall have the power to impeach, and Section 2 also provides that the Senate shall have the power to try all impeachments. There's no doubt that Donald Trump was a civil officer at the time of his impeachment by the House, and so it can be reasonably argued that the Senate has the unqualified power to try that impeachment at the time it was conveyed to the Senate. Moreover, there are significant benefits to such an outcome. These include the timely exposure of the former president's constitutional crimes, which are not the same as the common crimes prosecutable by the Department of Justice in the states. It's true that a select committee of the House is examining the events of January 6, but it is unlikely that the nation will be as focused on their findings or focused in the same way, the same profound way, as it was for Trump's second impeachment. While I am not persuaded that the former president can be prevented from running for and holding future office because he could not be convicted of an impeachable offense as he was no longer a civil officer, this very conclusion counsels the exposure and the denunciation of his constitutional crimes so the public can be inoculated against any future political activity by Donald Trump. On this panel, we have proponents of the view that a person no longer in office can nevertheless be impeached and convicted, though obviously not removed. Brian Colt, one of the country's greatest experts on this subject, is not alone, and we may want to discuss this issue in the questions. There are narrow and broad constructions of this view besides Brian's. Some believe that, broadly, any former civil officer can be impeached and convicted. The Congress, on this view, could impeach President Carter in order to prevent him from running for any political office or holding any official appointment. Others believe that in a special case where a sitting president has been validly impeached, he should not be permitted to thwart his conviction by resigning or running out the clock, that is, delaying a Senate conviction until after January 20 of his last year in office. I'm a skeptic of these conclusions, although my view, I believe, is decidedly a minority one. In the first place, there is no constitutional warrant for the power to impeach or try or convict persons who are not civil officers in order to prevent them from running for office. Although I have no doubt that should the Republicans take the House this year, some member will introduce a resolution to impeach Hillary Clinton for just this purpose and on just those grounds. I wonder how many of you listening to this symposium are aware that just such a resolution of impeachment was introduced in 2016 to impeach Hillary Clinton, although she was no longer a civil officer at that time. Nor should it surprise us that some persons rue the fact that when the Republicans controlled the House in 2017, they did not impeach Joe Biden, who was also out of office and not a civil officer. The basis for impeachment, who may be impeached, and for what crimes, and with what effect, are clearly spelled out in Article 2, Section 4, and nowhere else. Section 4 states that the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. As I said at the outset, there is no authority granted Congress to impeach and convict persons who are not civil officers of the United States. The former president no more remains a civil officer than a former undergraduate remains a college senior. There are other reasons to resist augmenting this power. There are structural reasons. Do we really want to enlarge the power of Congress to start disqualifying its potential opponents from office? There are ethical arguments. Once the possibility of disqualification from holding future office is untethered from the removal from civil office, Congress's acts began to look a lot like a bill of attainder. That is, punishment by a legislative body without a criminal trial. Indeed, many advocates of that position do so on the basis that otherwise, one punishment envisaged by Article 2, disqualification, would be thwarted by a canny and timely resignation, and that criminal conviction would be too difficult. I'm happy to discuss the precedents usually trotted out in these debates, Blunt, Belknap, but even their most ardent advocates cannot really think these are strong precedents, as both men were acquitted. Moreover, more recent precedents, judges who were impeached and who promptly resigned before a Senate trial, prompting a request by the House that the bill of impeachment be returned, and the case of Richard Nixon, suggests that yes, conviction must be linked to holding civil office. But my general point is that the second impeachment of Donald Trump, including perhaps even the faux trial in the Senate, were constitutionally permissible and politically and morally helpful. Although I concede Brian Colt's, I thought, very perceptive remarks that there's a lot to that story, and certainly at least two sides. What I resist is the idea of a second impeachment marred by an unconstitutional conviction. It would be the ultimate achievement of Trump's contempt for law if he were able to provoke Americans into running roughshod over the Constitution in order to rebuke him. Let me say one last thing about Trump's second impeachment and the argument that he could not constitutionally be convicted. The most respected media outlets call this argument, and I quote, a mere technicality. The 19th century, at best ambiguous Blunt and Belknap cases were characterized, and I quote, as strong precedent for the ability of Senate to convict former civil officers. Richard Danzig and I, who wrote an op-ed piece on this point for the Washington Post, were said to be eccentrics, which at least speaking of Richard is not true. But the journalists didn't get their opinions from nowhere. They got them from academics who were outraged that Trump might escape his comeuppance, that he might actually run and win the presidency again. I do think this is a grave mistake. That constitutional hardball is really no more than a reflection of an underlying lack of faith in the Constitution and the methods by which it is construed. Thank you.
Thank you very much, Professor Bobbitt, for those very enlightening remarks. I'm already looking forward to the Q&A because I think we're going to get some good discussion out of that. But before we get to that, I'm very happy to say we get to hear from Professor Victoria Norse, who is Ralph V. Whitworth Professor of Law at the Georgetown University Law Center, where she teaches courses in legislation, regulation, and constitutional law, and also directs the Center on Congressional Studies. Her varied scholarship on statutory interpretation, separation of powers, and the legislative process has appeared in the Yale Law Journal, the Stanford Law Review, the NYU Law Review, the University of Chicago Law Review, the University of Pennsylvania Law Review. I could go on, but I think you get the point, to name only a few. From 2014 until 2015, Professor Norse served as counsel to the Vice President of the United States, whom I understand from news reports now has a different job. Her most recent book, The Impeachments of Donald Trump, collects a curated record of the two most recent impeachments. Thank you very much for being with us today, Professor Norse. I look forward to your remarks.
Well, thank you very much for having me. I unfortunately have to follow up two extraordinarily wonderful discussions of the difficulties of the second impeachment of Donald Trump. And I'm delighted to be invited here. Frank Bowman and I did some work together at Georgetown. He comes out and edifies me. I am not an expert on impeachment. I wrote the book, here, shameless self-promotion, because I wanted students to learn something about impeachment. And as Cass Sunstein said, no one ever teaches impeachment in constitutional law. Thankfully, Professor Bobbitt taught his students at Columbia my book, and I'm delighted to thank him for that, because it's a way to show how Congress actually acts in an impeachment. We have an enormous amount of contempt for Congress today, and I'm familiar with that. But I do believe that our Constitution is less, and our legislature will be less, if we have and continue to have contempt for them. I write in the book that politics goes by many, many different names, and I ask the students to be quite clear and precise, as a textualist would be, about what they mean by politics. Do they mean party and partisanship, or do they mean something entirely different, which is democracy? For without Congress, we have no democracy. And if it is contemptible, perhaps we are the ones responsible for that contempt. So the second impeachment, I was going to deliver some remarks, and I'll talk a little bit about that, but then I'll respond to some of the remarks made earlier about my views, which are generally in the same line, but not necessarily precisely on point. So what is the purpose of impeachment? I write it as someone who knows about Congress, and I argue that it's a function of oversight. Oversight powers, even by this Supreme Court, have been said to be very, very broad and very important. But also there are very specific provisions. Professor Bobbitt went through them in the Constitution, and they should be respected. But nevertheless, Congress has enormous power to set the procedures under Article 5 and to set its own agenda. I call it a democratic fire alarm because it's not supposed to be common, and there's no reason to think it ever would be, and that has nothing whatsoever to do with the standard for impeachment. So you can argue all you want about whether the statements are about maladministration or high crimes and misdemeanors. I think everyone now agrees a crime is not necessary. And then they go into, well, what politics would be sufficient? Well, if you look at this from a very raw structural sense, you look at the voting requirement, 2/3. If you know anything about voting in the Senate, and I lived there during a world where in the 1990s, yes, I worked for a guy named Biden when he was in the Senate too. And 2/3 is bigger than the filibuster. You know, this is huge. Getting to 60 is huge enough. All legislation at the time required that, anything controversial. It's not new. 2/3, which is the constitutional requirement, is tremendous. So you know at the start that this is going to require super unanimity. So my approach toward this is more like a political scientist, I would suppose, which is to say that you don't really need to know what the precise standard is to know that it's going to be very, very difficult to meet. The standard is ultimately set by the public. It's not set by lawyers. It's never adjudicated. And the focus on the text is important, but it won't tell you all that much, in my view. The most important thing we know is that it was supposed to be hard. You get that from the 2/3. You also get that from when it occurred during the debate. Professor McConnell's remarks are important. He's written a brilliant book about the executive power. But one of the things about the high crimes and misdemeanors standard is that it comes after the entire structure of our government is set finally. They can't figure out how the president is going to be elected. Shock and horror to the viewers. He was supposed to be elected by the Congress. Oh, horrors. They changed that with the Electoral College. They gave him a national audience, in part because they didn't want a cabal in Washington from electing the president. And when that was set, then they finally set the standard. So they knew it was going to be an interdepartmental structural clash, unlike what it would occur in a parliamentary democracy. And I believe they wanted it to be very hard. Even if I say it's supposed to be political, what I mean by that, it's democratic. It comes from the people. They are the ones who ultimately decide. Now, what does that mean for things like futile impeachment or the likelihood that we'll have lots of impeachments? And should Jamie Raskin or Representative Raskin, former Professor Raskin, who'll be addressing you, have thought, oh, this is a futile impeachment, I'm not going to go there. Or are we going to have lots of impeachments? This is always the argument on behalf of President Trump at the time. I've written about what I call the political safeguards of impeachment, referencing, I suppose, Professor Wexler's political safeguards. And there are lots of problems with that argument, and there are problems with this argument, but I'll just give you the gist of it, which is to say, unless you can get a median voter in the House to assess this following calculation, you won't get an impeachment. You need the median voter in the House, someone, let's say, like Abigail Spanberger, who was elected and said, oh, President Biden, you're not Roosevelt, just be normal. She's a median voter. She has a mixed district. She's not going to vote for impeachment because she cares more about her own reelection. And her reelection will depend not upon impeachment. Why? People don't like impeachment. We know that from the Clinton impeachment. He became more popular during the impeachment. We know that from the Trump impeachment. People want to know what's happening with inflation, the kitchen table economics that I heard on the radio yesterday from Senator Scott about inflation. They want to care about Ukraine, which is menacing on the border. They don't necessarily want, I'm sure someone's introduced an impeachment resolution, or haven't, will, against President Biden, but that doesn't suggest that it actually will happen. And it's not because you measure it by futility in some abstract sense. And I think Professor Colt, who had a very subtle argument, knows this. It's that you figure out, if you're in at the House, whether it's worth your while. And that depends upon a lot of calculations about your representation and your ability to get reelected. It also depends, as Professor Colt said, about what you think about what's going to go on the Senate. There's an old joke that it's not Republicans and Democrats who hate each other in Washington. It's the House and the Senate. They literally never walk to each other. When they do, it's a big deal, right? And so, yes, the House is going to say, "Oh, that darn Senate, they're never going to do this." But I think they felt very much, and it'd be interesting to hear from Representative Raskin later, that it was their constitutional duty. They believed that there was a constitutional offense, and they believed they had enough of the American Republic behind that. After all, they did storm the Capitol the first time. As such, the bonus army did its own thing, but the first insurrection-like attack. And they believed they had a duty, and I think they did as well. And I know that our panelists believe that as well. I do say that there are calculations that need to be made about whether you all actually will use the powers of the House to do this. It requires an enormous amount of unanimity. It requires the Speaker. It's not a simple procedural maneuver, as Professor McConnell indicated, and it definitely isn't easy in the Senate. So I think these things will only happen in extreme circumstances. I think history shows that. I think, of course, we've had more impeachments than we've had before. Why? Hyperpolarization. Why? Redistricting. Why? Lots of political factors have been built into this to make it more likely. So finally, I just want to say a couple things about terminology. I don't think we should call this a late impeachment because, as Professor Bobbitt indicated, President Trump was impeached during his time as a civil officer. The Senate did not try him, and I do not know the answer to this. Maybe somebody on this in Symposium knows the answer to this. Was not tried in the Senate until after he left office. They could have tried him. And Nancy Pelosi argued that Senator McConnell kept that from happening. She said this in a press conference. I have no idea whether that's true or not. I do know that the majority leader has enormous power in the Senate to set the schedule. But that raises another argument about why you might want to hold the particular Trump trial, even if you would not want a late impeachment in any other case. And that is because the Senate should be stopped from making such an argument because of bad faith in setting the date of the trial. Now, I don't know, I'm not arguing that, but I'm interested in what the panelists and others have to say about that in this particular case. So having said that, I will also say, as far as censure, I think that Professor Colt is more sanguine about that than I am. In a world where there is no reality, the censure wouldn't have had much reality either for this particular individual. I don't think that we will be able to predict much if we do return to the reality plane from this particular adventure. If we had thought there would be many impeachments after Johnson, we would have been wrong. His also unique operation, and that's how it should be. They should be extremely rare. And I certainly hope Hillary Clinton is not impeached. I don't think the Constitution allows her to be impeached. And I hope that the members of the House would see that it wasn't in their self-interest to waste their time on such an effort. Thank you.
Thank you very much, Professor Norris, and to all of our panelists. I thought those were terrific opening remarks, and I think we can already see some of the points of convergence and divergence in your various views. So I'm excited to get into some of those. But first, I think I should give Professor Colt the opportunity to speak to the constitutionality of so-called late impeachments. Apologies for using that term once again, Professor Norse.
There are late impeachments. Hillary Clinton. Yeah.
I think Professor Cult's the only one who hasn't had a chance to opine on that specific question. So let's throw it to him.
Yeah, well, I I had a chance to opine on it back in 2001 with an article that was over 100 pages on this, and I'll try to condense what I have to say. So I think the problem is that Article 2, Section 4 isn't as clear as it could be. It doesn't say this is the timing of how things have to be. I read Article 2, Section 4 as limiting impeachment to the president, vice president, and civil officers, but as limiting it to them being in that role at the time of the offense and not at the time of the trial. And while removal is mandatory, if they're in office, it nowhere says that it is removability is mandatory before anyone can even try them. And so it's not clear. Now, what do we do when the text isn't clear? Well, we can look at other sources. And I think the most important one for me when I was looking at this in 2001 was the Hastings trial. At the time that the Constitution was being written, they were well aware that someone was being impeached after having left office. Hastings was on trial, and they mentioned the Hastings case not because of this, but that part of it, the lateness of it, seemed unremarkable to them. All the other things that they wanted to do differently from the British, they made sure to nail that down very specifically. This they didn't, in my interpretation of the text. So when I look at the text, I see it as allowing this. But a big part of those 100+ pages was talking about why, even though they can do this, they shouldn't. There are only a few kinds of cases where it'll actually make sense to do an impeachment of someone who's already left office, let alone a trial. If they've already left office, why bother? And usually they won't want to bother. But that's true of regular impeachment too. Usually they won't want to bother with that either. And so when you have a case like this, a president doing something on his way out of office, you have a case of Congress needing to vindicate its position in the branches of government. This was an assault on Congress. When you have those in place, I think it is appropriate in a way that it usually wouldn't be. And I don't think they should impeach Hillary Clinton either. But I do note that back in the 1800s, you would see people like John C. Calhoun saying, I used to hold this office. Impeach me. If you're making these accusations about what I did back then, impeach me. You can impeach me. John Quincy Adams, similar things. I will say this, and I'm glad that Professor Bobbitt put it this way. I do think that it is a close question, and I don't think that it was portrayed that way in the debate. I think they should have made clear that there are reasonable arguments on both sides, and I think that if they had done that, maybe more people would have paid attention to those arguments instead of just latching onto whichever one made their side win.
Terrific. Thank you. I want to see if I can just pick up right where we've left off and try and pose some questions of my own. So every year when I teach constitutional law, and I'm glad that some of my constitutional law students are here in the audience today, one of the first things I assign to my students is Professor Bobbitt's classic book, Constitutional Fate. And in that book, he masterfully goes through some of the modalities of constitutional interpretation. And our discussion today has really only focused on a couple of those. We've talked about the text of Article 2 and the various arguments that derive solely from the text. And there's been some brief discussion of some of the precedents, where, of course, we don't mean court cases, but rather we mean prior attempts and procedures used in actual impeachments. And Professor Bobbitt in his comments briefly mentioned the ethical modality, which was really the innovation that his book brought to constitutional interpretation, or one of the primary innovations. And I wonder if the panelists have thoughts on how we should think about the role of impeachment and how it fits into that ethical modality, which in his book, Professor Bobbitt described as a type of argument that draws its force from a characterization of American institutions and the role within them of the American people. So can we learn anything about how we should understand Congress's power in the context of impeachment from thinking it from this ethical modality. And on top of that, I'd love to hear more comments from the panelists about some of the precedents that are often trotted out to try to justify one or the other position about the constitutionality of these so-called late impeachments. And I'll open the floor to any of you, but I expect perhaps Professor Bobbitt might like to go first.
Sure, thanks. I would like to make 2 points. First of all, I think the wariness I expressed about letting Congress disqualify its political opponents from holding office, either by election or appointment, is a reflection of our constitutional ethos. We really don't want the power of choosing the members of Congress, the White House, even appointed persons, to rest solely with elected officials. We want the public to speak. It is a severe compromise of the democratic mandate to simply take someone off the table and put it beyond the reach of the public, however misguided we may think the public is. The second point I'd like to make is a point that is stressed in Professor Nurse's book, which I used in this seminar to, I think, wonderful effect. It's, if you haven't seen it, I hardly recommend it. And that is that the modalities of argument, these forms of argument that Professor Barnett just mentioned, have a wonderful utility outside the courts. Impeachment is not a matter for courts. And so, as with whether or not a president can pardon himself and other fanciful questions, there have been academics who said, well, who knows? Who can say? The Supreme Court hasn't ruled, and the Supreme Court will never rule on impeachment. But if we take Brian Colt's position to an extreme, that the only time one has to be a civil officer is when the impeachable offense has occurred, then presumably you can start impeaching and convicting dead people. You can treat them like the monuments that we're taking down over the country, and you can go back and get it right with Andrew Johnson this time and convict him, and so on. And no court will say no. But the sense of our people, the sense of the lawyers and journalists who instruct them, can use these forms of argument, like the doctrinal argument that Professor Barnett just mentioned, and come to a conclusion on their own. And that's one reason why I'm so wary of reading the text in a clever and even fanciful way, because that discredits these arguments. It makes them seem as though anyone can make any kind of argument. And so long as the court's not going to check you, there is no check.
Thank you. Professors Nurse or Colt, would you like to join in on that question? I've got plenty more if not.
I would, if you don't mind. I mean, I obviously, I think the book is brilliant. The Constitutional Fate is brilliant. I used the modalities in my own book because I thought it was important for students to understand constitutionalism outside the courts. That's kind of my shtick, because the Constitution is about creating a government. I mean, that's what it was supposed to do. It wasn't just to create courts. And we often read the text as juridical. It's all about the text as the court reads, is means is and a, very, very precisely and falsely, because it was supposed to create a system of government that had not only its mechanical aspects, but also its ethos. And so the representational provisions of the Constitution are some of the most important, and no one ever teaches them in textualism or even in originalism, because those are juridical. That's how a court deals with the text. But one of the most amazing things about the impeachment, if you actually read it, is how attentive the arguments were on both sides. And I emphasize this. Yeah, there were a little crazy arguments on both sides, but as a general rule, the members in the Senate, in the trial, the senators, they were taking their constitutional duty very seriously. They weren't making purely partisan arguments like you would say, I'm the enemy or you're not. Yes, they said it was partisan. That always happens. That's just a problem with the definition of what is politics. But I do think they took it seriously, and they used arguments that were ethical arguments, and those ethical arguments has to do with, and they're embedded in our history. So I don't see ethical argument as different or contrary to text or history. I think it is embedded in the history. This is why Professor Colt had to write an incredibly detailed article, which has now become famous. I hope you feel the love from those of us who would not actually spend the time to do all that history. But I also think that the ethical argument, as I said, is embedded in our history. We know from the Alien and Sedition Acts why we wanted to put our political enemies in jail. That is a very bad idea. I was happy to hear that Professor McConnell and I disagree on some things, but he believed that the first impeachment was based on that, and he believed that was true. And that we should not be putting our political enemies in jail. One interesting aspect of this impeachment is, yes, there was no political sanction for Donald Trump, but guess what? There's a lot of legal sanctions going on right now that may have more effect precisely because they are legal as opposed to political. But I do think the ethical argument is important, and it should not be seen as separate from textual or historical argument, but embedded in both the text of the Constitution and in history. So thank you.
Great, thank you. And if I could just jump in right there, because I've got a question for you, Professor Nurse, and I'm sure the others will have thoughts about it too. One of my favorite articles that you've published is the article that you published with Jane Schachter that I think was called "The Politics of Legislative Drafting." And the genius of that article was that everybody thinks about statutory interpretation from the side of courts, thinking about how courts ought to imagine Congress as intending various words to have various meanings using certain linguistic heuristics and the like. But your insight was to go ask congressional staffers whether they had any of these thoughts in mind when they went about drafting legislation. And I wondered if there couldn't be a similar kind of move in trying to understand the purposes and the virtues of impeachment proceedings. So I really appreciated Professor Colt's comments on sort of what the theoretical purposes of impeachment were. And I'm persuaded those are among the purposes of impeachment. But I wonder sometimes if we went to ask members of the staffers of the various committees whether they had in mind any other purposes and whether that would cast any light on what impeachment is supposed to achieve, or whether instead we ought to just think about these things solely from the outside.
What a brilliant idea, Professor Bennett. Come on down to Washington. Joshua Matz was on the panel last night, and he was working as a lawyer there, and he said he was incredibly impressed. I mean, I think Professor Bobbitt and I actually know each other from working on an ancient investigation called the Iran-Contra investigation, and I think he was pretty impressed by the lawyers there. People who are law professors tend to sort of look down on Congress, and yet there are pretty fancy folks who work there on these kinds of issues. When Congress wants to pay attention to law, it does. When it wants to pay attention to the Constitution, it does. So I think that would be a fascinating idea. There have been some tell-all books already. I'm not so interested in that. Like you, I would want to know more what they thought and about the Constitution, about different kinds of forms of argument. But I think that's a great idea. I was thinking about that last night when listening to, or last evening listening to Joshua Matz, who was talking about how he was shocked that they were reading the sources that Brian Colt had written about. I think they probably memorized Professor Colt's article.
Terrific. Okay, now I want to see if any of you have questions for one another. I've gotten a chance to pose several now, and I think we'll have some questions from the audience before long, but I see Professor Colt raise his hand. So why don't you start us off and ask a question?
Well, I wanted to answer the last question, weigh in very quickly on the ethical modality here. My take on it is that impeachment, one of the issues with impeachment is that it combines the questions of can we and should we in a way that makes it hard to disentangle sometimes. And I think that the ethical part of it goes much more into the should we than the can we. So I agree. My view is that the can we is very broad. maybe you could impeach Jimmy Carter, maybe you could impeach Andrew Johnson, but should we? I think the Constitution, in a lot of places, and this is one of them, leaves that judgment, leaves the ethical modality to things like defining who the decision maker is. So, for instance, there are no qualifications for who's on the Supreme Court. Could Joe Biden nominate my third grade son to the Supreme Court? I think he'd be great. He's particularly strong on administrative law. He's very collegial, but the Senate wouldn't confirm him. There's nothing in the Constitution that says that they can't, but there's a lot in the Constitution and there's a lot in the ethical modalities that say that they shouldn't. And how do we do that? By having the Senate vote. And that's the same way we would turn away an impeachment of someone who's dead. They would say we shouldn't. So I just wanted to get my 2 cents in on that.
That's terrific, and certainly that's your prerogative. I've actually got a question for you from the audience, Professor Kalt. One of our students here at Mizzou asks you spoke about the different realities of political parties and the balance of law and politics that affects, in your view, the usefulness of impeachment. She says, I remember much of the dialogue around the Trump impeachments being that not impeaching him would be a failure on the part of the Democratic Party. How do we convince the country in this atmosphere that censure can be a better alternative to impeachment? So I take the question to be, how can we make the case to the public that censure is a valid alternative and a useful one?
Well, I think by doing it, and I think that it would have been consequential. Here's my thought experiment on this. Imagine Donald Trump's reaction if there had been a censure resolution and there had been a lot of Republican votes, more Republican votes, to condemn him. He would not have taken that as nothing, I don't think. I think it would have been significant. If they had done it, it would have registered. I think that's my opinion, but I think it would have left a mark. And I think that's how you do it. You set a precedent. You see what happens, and when it works, then you do it again the next time.
Terrific. I want to see if there are other questions from the audience. Feel free to pose them in the chat function, and we'll get those relayed to our panelists. But I want to ask again whether any of the other panelists have questions for one another or would like to speak directly to some of the comments that have been made. Professor Bobbitt, go ahead.
I think this is sort of building on something that Victoria Nurse said. In the book, Impeachment, a Handbook, Charles Black said, with respect to impeachment, there can be no place for a snowstorm of telegrams, or we would say emails. And I want to register on my behalf and on his dissent from the idea that the outcome of impeachment, of the trial itself, the conviction, or the acquittal should be a matter of public opinion. I have no doubt that's where we are, and that we're moving towards that at warp speed. In fact, I think that we are in one of those rare periods, maybe for the third time, I think, in our constitutional history, counting the formation of the United States as the first time, when we are creating a new constitutional order. And I think the ubiquity and the increasing use and velocity of referenda, voter initiatives, recall votes, are all evidence of this. I very much take Brian Cole's point about the frequency of impeachments, and I think that will accelerate too. I think that we'll see more impeachments. I mentioned the ones I expect if the House goes to the Republicans, and I think the role of public opinion will increase. I simply deplore it, but I think that's where we're going. And I deplore it because I think that impeachment is a matter of law. And I think the textual requirement that the Senate try the case of impeachment, the historical arguments based on the decision to put the trial in the Senate rather than the Supreme Court, and the defense of this, that the Senate would act as a jury, that it would be detached, that it would try the case with dispassion and try it as a matter of law. Counsel that it was envisioned this would be a matter of law and not public opinion. But I think Professor Nurse is right. That's where we are. And I think we'll be headed even further in that direction.
Thank you. Yeah, I'm struck, as I look back at Charles Black's thinner version of the handbook, that he thought that sitting members of Congress had a really solemn duty, almost a legal and ethical duty, to comport themselves in a particular manner during the course of the impeachment proceedings. And I don't know exactly what it was like during the impeachments that he was writing about, but I have to think that it was not anything like what we saw in the previous two in terms of explicit political statements by existing members of Congress. And I take the point that that may be lamentable, that things have changed in that way. But I also wonder, we talk about impeachment as a constitutional process, but there is kind of a democratic dimension to it. And so I wonder how we think about a process that requires a supermajority vote, which we might otherwise think of as almost counter-majoritarian, nevertheless being a way to vindicate sort of majoritarian values within the 4-year period of a president's term in office when it's a president who's being impeached. The only other constitutional provisions that require a supermajority threshold, the amendment process and the process by which the presidential veto can be overridden, are all either pro-democracy or neutral on that point, I think. And so I wonder, how do we think about the pro-democracy role of impeachment or the counter-majoritarian role of impeachment?
Well, could I just say something? I mean, I agree that we have gone to a more politicized version of impeachment. As a literal baby, I watched the Nixon hearings, and I remember Barbara Jordan, making an extraordinary constitutional speech. It was truly inspiring for a little girl like me at the time. I don't, as I said, I think that the managers handled the impeachments quite well. Some of them were inspiring, like Stacey Plaskett from the Virgin Islands. It turns out to be a pretty good prosecutor. When I say that the politics, I think our politics are very raw right now. I think they are in an real space. I've never seen anything like it. It's very disturbing. I do think that one of the things that gives me heart is that, in fact, most of the lawyers treated the impeachment as the rule of law. They did discuss the Constitution. And that's why I could write the book. I wanted to have people to have more faith in the process as a legal matter. When I say that politics will ultimately, or the public will determine whether in fact representatives will actually pursue an impeachment, I'm not saying it should be illegal. I'm just sort of giving a realpolitik view to why I think that impeachments don't happen as much as you would think. If impeachment were solely about partisanship, it should happen all the time. And it hasn't. And thankfully, I think, as I said, that they should be very rare. So it, as several of the people have said, it is both about democracy as well as partisanship, as well as law. And I don't want to be misheard as saying it should be lawless in any way. I think that's wrong. I think Professor Bobbitt rather eloquently explained why it should be a matter of our Constitution, and we should pay attention very clearly to all the modalities to understand, what we think of as a proper impeachment and what is not. My hope is that when people look back at the insurrection, they will see that there was no other choice in this particular circumstance, despite the legal issues about it being after President Trump left office.
So, I'm happy to have more crosstalk among the panelists if people would like to respond directly. So please just indicate in some sort of visual way that that's the case, and I'll be happy to let you do that. But I do want to think about, before we run out of time in about 10 more minutes, what the takeaways are from this most recent impeachment that will be used as a sort of doctrinal or precedential argument when inevitably the next impeachment process arises. And one of the nice things about being removed somewhat in time from an impeachment is that we don't yet know the political party of the next president who might be impeached. And so perhaps we can get on the record and set in some degree of stone what we think the rule of this most recent impeachment was. If we were to describe the holding of the impeachment as if it were a court case, what does this experience teach us that we carry forward, not about Trump or this particular political moment, but about this kind of legal process that is impeachment that we might apply in the next case?
Well, there is a famous philosophical remark that the answer to the wrong question is not a wrong answer. The answer to the wrong question is no answer at all. And I think because there was an acquittal, that there's very little doctrine that will come out of the Trump impeachment or the Clinton impeachment for that matter. And that's really one more reason why I think Brian Colt's suggestion of censure is right on target. And I deeply regret that if a speaker was the decisive voice against it, that we did not pursue.
Professor Colt, what are your thoughts? Do you think that there is an enduring lesson from this, or is it purely futile, as I think you set out? Perhaps the lesson is a cautionary one.
Well, I would have thought the lesson from the Clinton impeachment was cautionary. Don't do you come at the king, you best not miss. To quote Omar Little, paraphrasing Emerson. I think that that didn't take. I think that there is just too much of a sense that they were both sides are speaking to their own reality, again, to reality system. I do think, though, that just thinking about the late impeachment aspect of it, the fact that we had a majority vote in the Senate for jurisdiction, but not 2/3, sort of put us right back where we were, because that's what we had with the Belknap case, a majority vote that allowed the trial to continue, but a 2/3 vote that if it hadn't been, you look at the reasons that people gave, if they hadn't been trying someone who was already gone, there would have been a conviction, both of Belknap and I think probably of Trump as well. So what do we take away from that? Again, it's the merging of the can and the should. And so the next time up, that's what's going to happen. The proponents of the impeachment are going to say, well, we can do this, and we just need a stronger case than they had last time. And because of the true reality system, they'll think, well, we have a stronger case. Like, reality, this is reality. Everything we're saying here is true. We can't lose. And so it'll happen again and again. Even if the president has already left office. I think it would have been better to have the Senate reject jurisdiction and close that door, or to get a conviction and say definitively that it was open, than to have the muddled precedent that we got.
I don't think precedent works in Congress the same way it works in courts.
True.
So, they are perfectly free. They don't feel bound by stare decisis in the same way. They do operate on precedent, so if you voted for a law X, it's very hard for you to not vote again on something similar, because you'll be seen as a flip-flopper. It's inspired by the representational relationship or, their self-interest. So they do have precedent on legislation. They did look at the precedent. Joshua Matz said he was reading all that, Hastings. I think they really did pay attention to that because it's outside time. So it gives them more legitimacy in a highly polarized world. I'm hoping for reality to come back after the pandemic. Myself, I do think that this was an extraordinary president and an extraordinary disruption. It was our second civil war. It's still going on now. There's a battle over on Ukraine. We won't know really the measure of this for some time, in my view, because it works itself out in the future precedent of politics. My fervent hope is that we don't see a spate of impeachments. Historically, there are in state court. I know this from another book I wrote about a guy named Alfalfa Bill Murray in Oklahoma in the 30s. Impeachments tend to breed impeachments because it's political payback. So I agree that there will be people who want to do that. The question is if we are so polarized as to convince people that that reality is all that there is out there. If there are people in the middle who don't necessarily agree, that's a buffer zone. If there is no buffer zone, we're in trouble. We're in a lot of trouble, and the trouble is probably more than impeachment.
We have about 5 minutes left. So I have in mind the idea that each of you might like to have some final word, some opportunity to respond to something else that's been said. And since he was the longest to go to speak, I'll let Professor Bobbitt have the first bite at that apple if he would like.
Well, I'll just tell you my reaction to the panel. I found this a very fruitful discussion. I admire these scholars, of course, so I expected such, but and I don't agree with many of the things that have been said. I prefer a little sharper lines than I think Brian Colt does, and Victoria Nurse and I may agree on how deplorable a spate of impeachments would be, but I think that also is driven by public opinion. I think the public wants a more insistent role in these matters. And I think that there's a large movement, and you saw this in the commission on the United States Supreme Court. There's a large body of opinion that thinks that decisions according to law are anti-democratic, that only those decisions that are done by popular majorities, not through their representatives, not elections, but decisions taken by a majority of people are the gold standard for democracy, and that these are anti-democratic moves, including impeachment itself, which nullifies a presidential election unless it is ratified by opinion polls. I think this is as you gather, I think really deplorable. And I hate to see it building on all these other developments like the referendum, like voter initiatives, and like recall votes. But that's where we are, I think. And I also think that's where we're headed.
Thank you, Professor Bobbitt, and thank you for being here. Professor Colt, would you like to make some concluding remarks?
I'm going to take a left turn here and talk about the 25th Amendment, which we haven't talked about, but was the subject of my last book. And it did come up after January 6th, the Pelosi ultimatum. If you don't invoke 25th Amendment cabinet, we will move forward with impeachment. I thought it was very interesting to see how little traction that got. And I think that was by design. When the 25th Amendment was designed to get rid of a president over his objection, they would have needed not just the cabinet, not just 2/3 in the Senate, but 2/3 in the House, not a simple majority. They did that on purpose so that it wouldn't become an end run around impeachment. And if it was all about politics, maybe that would have played out a little differently. But it didn't matter because of the way that that Birch Bayh, that the drafters of the amendment decided who the decision makers were, not what the standards were. We could argue about what the standards are, but who the decision makers are. And by getting that right, the 25th Amendment was not abused as it might have been there. So I think that's interesting, and I think it reinforces the importance of that feature of the Constitution's design.
Terrific. Thank you, Professor Colt, for your very thoughtful comments. Professor Nurse, would you like to have an opportunity to make some concluding remarks?
Well, I just want to thank you all for putting this together. It was a wonderful discussion. I'm sitting all alone in my home writing another article about, the Supreme Court. So I'm delighted to be here and to talk to your students. And thank you for the wonderful questions, Professor Bennett. I'm not happy about politics today. My views were built in a different world where, in fact, Senator Biden used to routinely loan me to Republicans. I probably spent more time with Republican staff than I did with Democratic staff. So I agree with Professor Bobbitt that we are in a hole if we think that everything should be run by sort of a hyper-majoritarianism. We need to start understanding each other better. My culprit personally is not impeachment. It is the fact that the Supreme Court refuses to idealize the fact that partisanship is not a constitutional interest. in redistricting. This court was never going to hold that, but in fact, there is no constitutional interest in a party because the Constitution does not recognize parties. So that's my evil of the day rather than impeachment.
Terrific. Well, on behalf of the Kinder Institute on Constitutional Democracy and the Missouri Law Review, I want to thank all three of you for a very engaging discussion, which I think enlightened everybody who listened to it. So thank you very much. And for those of you in the audience, we will be hearing from Senator Durbin in about 15 minutes, which will be preceded by some comments from our esteemed Frank Bowman, and then some question and answer that will be a larger format for questions from the audience. So I hope you stay tuned, and I look forward to
We don't know why we can't, why we still have this stupid,
Yeah, I was going to see if I could.
it just won't go away. Well, welcome back to the 2022 Missouri Law Review Symposium on the 2 impeachments of Donald Trump. I apologize for our starting a little bit later with this session. And I'll have to continue with one other small apology, that from Senator Durbin. Unfortunately, because of the recent resignation of Justice Breyer and the necessity of arranging for and facilitating his replacement on the Supreme Court, Senator Durbin's duties in the Senate, particularly his role as chair of the Judiciary Committee, obliged him at the last minute to bow out of a live appearance before us today. However, he was kind enough, as is his wont, to at least provide a recorded statement on the subject for today, and we're going to hear that here in just a moment. So what we're going to do in lieu of his unfortunate, or in lieu of his live appearance, is I'm going to introduce him in the normal way. Then we're going to actually hear one of his floor speeches during the first Trump impeachment. Then we will hear his recorded statement made specially for this symposium. And then we'll open up the floor both here in the courtroom at the law school and to those of you online to ask any questions you would like. And I have here with me today Professor Tommy Bennett, our wonderful young constitutional star here at the law school, who was the moderator of the last panel, and he and I will be available to answer any questions that you may have. So with no further ado, a couple remarks about Senator Durbin. The first time I ever encountered Senator Durbin personally, I was sitting at my kitchen table here in Columbia one day in the fall of 2019. And I get a call on my cell phone. And I pick it up, and the voice on the other end says, "Frank?" I said, "Yes." He says, "Hi, this is Dick Durbin." I said, "Yeah, sure. It's Dick Durbin, right?" In fact, it was Dick Durbin. And because we'd never spoken before, I'd never met. And he was kind enough to reach out to me personally because he'd read all or portions of my recent book on impeachment. And he was kind enough to invite me to assist his staff periodically in the upcoming impeachment, which, to the best of my small ability, I did from time to time, but I can't claim to have made any particularly major contributions. Later, I got to meet Senator Durbin on a number of occasions in person on Capitol Hill. He was kind enough to invite me to his office, and he and his staff arranged for me to get a gallery pass to watch portions of the first Trump impeachment. So I would go to his whip's office there in the Capitol and wait with his staff, and then they give me the pass, and I go and sit and watch. And it was, I must say, not only incredibly gracious on the part of Senator Durbin, but also a really remarkable experience for me, whose writings about impeachment had been of a purely theoretical kind. And he enabled me to actually watch the first Trump impeachment, or at least portions of it, and provided me with some really fascinating memories and some insights into how the whole thing actually worked. And I must say that in all my experience with Senator Durbin, he has been uniformly gracious, delightful, considerate, intelligent, and altogether the best kind of public servant. A few words about his background. He was born in East St. Louis, albeit over in the Illinois side of St. Louis. He graduated from the School of Foreign Service and the Georgetown University's Law Center. He, in 1982, was elected to Congress for the first time in the House of Representatives. 14 years later, in 1996, he was elected to the United States Senate. He's been a member of the Senate leadership for many years. In 2005, he became a Senate Democratic Whip, the second highest position in the Democratic leadership. And he's been Senate Majority Whip since 2021. His position in Democratic leadership meant that he served a central coordinating role for Senate Democrats in responding to both House's decisions, both House decisions, on 2 occasions to impeach Donald Trump. Durbin was participating in the 2021 Electoral College vote count when rioters stormed the Capitol, along with other senators and staff. Senator Durbin ran out of the Senate chambers after the attackers, whom he referred to at the time as extremists, breached the Capitol. He then evacuated to a secure location together with Speaker Pelosi, Senate Minority Leader McConnell, and Senate Majority Leader Schumer. And therefore, he has not only a professional but highly personal interest in the outcome of both impeachments of Donald Trump. So, with no further ado, if our wonderful technical people can go ahead and play the first item on our agenda, which is Senator Durbin's floor speech in the first Trump impeachment. Can we do that?
Mr. President, Benjamin Franklin knew the strength of our Constitution. Mr. President, Benjamin Franklin knew the strength of our Constitution, but he also knew its vulnerability. His words, oft repeated on this floor, "A republic, if you can keep it," were a stark warning. Franklin believed every generation could face the challenge of protecting and defending our nation's liberty-affirming document. We know this personally. Before we can legally serve as senators, we must publicly swear an oath to support and defend the Constitution of the United States. A trial of impeachment, more than any other Senate assignment, tests the oath each one of us takes before the people of this nation. The President's legal team warns us of the danger of impeachment and conviction. They tell us to think carefully about what the removal of a duly elected president could mean for our democracy. But if we should have our eyes wide open to the danger of conviction, we also cannot ignore the danger of acquittal. The facts of this impeachment are well known, and many Republicans concede that they are likely true. They believe, as I do, that President Trump pressured the Ukrainian president by withholding vital military aid and a prized White House visit in return for the announcement of an investigation of the Bidens and the Russian-concocted CrowdStrike fantasy. Some of these same Republicans acknowledge that what the president did was inappropriate. At least one has used the word impeachable, but many say they're still going to vote to acquit him regardless. So let's open our eyes to the morning after a judgment of acquittal. Facing a well-established election siege by Russia and other enemies of the United States, we, the Senate, will have absolved a president who continues to brazenly invite foreign interference in our elections. Expect more of the same. A majority of this body will have voted for the president's argument that inviting interference by a foreign government is not impeachable if it serves the president's personal political interest. We will also have found for the first time in the history of this nation that an impeachment proceeding in the Senate can be conducted without any direct witnesses or evidence presented on either side of the case, and that a president facing impeachment can ignore subpoenas to produce documents or witnesses to Congress. Alexander Hamilton described the Senate as the very best venue for an impeachment trial because it is independent and dignified, in his words. When the Senate voted 51-49 against witnesses and evidence, those 51 raised into question any claim to independence or dignity. In addition, an acquittal will leave the extreme views stated by the president's defense counsel, Alan Dershowitz, unchallenged. First, that abuse of power is not an impeachable offense. Second, that the impeachment charges against the president were constitutionally insufficient. And third, his most dangerous theory, that unless the president has committed an actual crime, his conduct cannot be corrupt or impeachable, as long as he believes it was necessary for his reelection. By this logic, Professor Dershowitz would have excused Richard Nixon's ordering of IRS audits of his political enemies. Mr. Dershowitz has created an escape clause to impeachment which is breathtaking in its impact and unfounded in our legal history. We've all received a letter signed by nearly 300 constitutional law scholars flatly rejecting the arguments offered by the president's defense team. I ask unanimous consent the scholar's letter be entered into the record.
Without objection.
Thank you. Yet a verdict of acquittal by the Senate blesses the professor's tortuous reasoning. An acquittal verdict would also give President Trump's personal attorney, Rudy Giuliani, a pat on the back to continue his global escapades, harassing American ambassadors whose service he distrusts and lounging at European cigar bars with an entourage of post-Soviet amigos. More than anything, a verdict of acquittal says a majority of the Senate believes this president is above the law and cannot be held accountable for conduct abusing the powers of his office. And make no mistake, this president believes that's true. On July the 23rd, 2 days before his phone call with President Zelensky, President Trump spoke to a group of young supporters and he said, and I quote, "I have an Article 2 where I have the right to do whatever I want as president." This is the dangerous principle that President Trump and his lawyers are asking us with a verdict of acquittal to accept. Under the oath I have sworn, I cannot. What does it say of this Congress and our nation that in 3 years we have become so anesthetized to outrage that for a majority in this Senate, there is nothing this president can do or say that rises to the level of blushworthy, let alone impeachable? Nearly 6 years ago, I traveled to Ukraine with a bipartisan group of Senate colleagues led by John McCain. It was one of the John's whirlwind visits where we crammed 5 days worth of meetings into 48 hours. We arrived in Kyiv on March 14, 2014. It was bitterly cold. Ukrainians had just ousted a corrupt Russian-backed leader who looted the national treasury and hollowed out their nation's military. They'd done so by taking to the streets, risking their lives for democracy and a better future. More than 100 ordinary citizens in Kyiv had been killed by security forces of the old government simply because they were protesting for democracy. Seeing Ukraine in a fragile democratic transition, Vladimir Putin pounced on them, ordered an invasion, and occupied Crimea. Putin and his thinly disguised Russian thugs were on the verge of seizing Donetsk in the east. I asked the Prime Minister what Ukraine needed to defend itself. He said, everything. We don't have anything that floats, flies, or runs. Many may not appreciate how devastating Russia's war on Ukraine has been to that struggling young democracy. Their costly battle with Russia was for a principle that is really basic to America's national security as well. In a country with 1/8 of our population, more Ukrainian troops have died defending Ukraine from Russia than American troops have perished in Afghanistan. During the months President Trump illegally withheld military aid, as many as 24 Ukrainian soldiers were killed in battle. By withholding security aid from Ukraine for President Trump's personal political benefit, he endangered the security of a fragile democracy. Can there be any deeper betrayal of a president's responsibility than to endanger our national security and the security of an ally for his own personal political gain? And to those of my colleagues who describe the president's conduct as merely inappropriate, I disagree. Disparaging John McCain's service to our country is disgusting and inappropriate. What this president has done to Ukraine crosses that line. It is impeachable. I'll close by remembering two public servants who, like us, were called by history to judge a president. Tom Railsback passed away as this impeachment proceeding began. He was 2 days shy of his 88th birthday. I knew Tom. I considered him a friend. In 1974, Tom was a Republican congressman from Moline, Illinois, and a member of the House Judiciary Committee. He regarded President Nixon as a political friend. He believed that Richard Nixon had achieved much for America, including the opening of the door to China. After studying the Watergate evidence closely, Congressman Railsback came to believe that Richard Nixon had violated the Constitution. When President Nixon refused to turn over records and recordings requested by Congress, Tom Railsback took to the House floor to say, if the Congress doesn't get the material we think we need and then votes to exonerate, we'll be regarded as a paper tiger. When he voted to impeach President Nixon, Tom believed it was probably the end of his career, but he was elected 4 more times. To his dying day, Tom Railsback was proud of his vote. He voted for his country above his party. Bill Cohen, also a Republican, was a freshman congressman at the time and a member of the House Judiciary Committee. He studied the evidence with Tom Railsback and worked with him to draft articles of impeachment. Bill Cohen received death threats, and he thought his votes to impeach President Nixon would be the end of his political career. But he went on to a distinguished career in the House, 3 terms in the Senate, and served as Secretary of Defense. Listen to what Bill Cohen said recently of President Trump's actions, and I quote, "This is presidential conduct that you want to be ashamed of. He is corrupting institutions, politicizing the military, and acts like he is the law." And then Cohen added, "If the president's conduct is acceptable, we really don't have a republic as we've known it anymore." May I respectfully say to my Senate colleagues, Ben Franklin warned us of this day. I will vote guilty on both articles of impeachment against President Donald John Trump, on Article 1, abuse of power, and Article 2, obstruction of Congress. But at this moment of high constitutional drama, I hope my last words can be a personal appeal to my Senate colleagues. Last night, many of us attended a State of the Union address, which was as emotionally charged as any I have ever attended. As divided as our nation may be, and as divided as this Senate may be, we should remember America has weathered greater storms than this impeachment and our current political standoff. It was Abraham Lincoln, in the darkness of our worst storm, who called on us to, quote, "strive on to finish the work we are in, to work to bind the nation's wounds." After this vote, and after this day, those of us who are entrusted with this high office must each do our part to work to bind the wounds of our divided nation. I hope we can leave this chamber with that common resolve. I yield the floor. I want to thank Professor Frank Bowman, University of Missouri Law Review, for holding this symposium on the impeachment trials of President Donald Trump. The topic is critically important and timely. It was just 2 years ago this month that the Senate acquitted President Trump in the first impeachment trial, and 1 year ago this week he was acquitted in his second trial for inciting an insurrection against the government of the United States. Now, in the first trial, Republican senators voted to prohibit the trial managers, the actual prosecutors, from subpoenaing any witnesses or documents. They won because they were in the majority. Before both trials, enough Republican senators, known as jurors, announced that they had already made up their minds to acquit the president, that the not guilty verdicts were essentially rendered even before the trial started. That raises an obvious question. The Constitution sets a high bar, 2/3 of the vote the Senate to convict and remove a president from office. In the 4 impeachment trials of 3 different presidents, that supermajority threshold has never been met. The closest, 1868, President Andrew Johnson escaped conviction by a single vote. The whole world watched in disbelief as Donald Trump summoned a mob to Washington, told them they had to, quote, fight like hell, pointed to the Capitol, turned them loose, and did absolutely nothing for hours to stop the pillaging and carnage. Even as police officers were being poisoned with bear spray, pummeled with weapons, including iron bars and even flagpoles. I was in the middle of that horror. I lived through it. The whole world witnessed it. And yet only 7 of the 50 Republican senators voted to convict President Trump in his second trial. Combined with all 50 Democrat and independent senators, that made for 57 guilty votes. A clear majority, but still at least 10 votes short of what was needed to remove President Trump from office. So here's the question. Given the preordained verdicts, were the 2 impeachment trials of Donald J. Trump a mistake, a waste of time? In this age of hyperpartisanship, is it even possible for the Senate to remove from office a president who commits high crimes and misdemeanors? Or is impeachment now just an empty threat? Before I address those issues, let me give you a bit of my background. In addition to now chairing the Senate Judiciary Committee, I'm one of only 14 senators in the history of America who has served as a juror in 3 of the 4 presidential impeachment trials. I missed the Andrew Johnson trial for obvious reasons. Despite the verdicts, I believe that both of the Trump impeachment trials provided sufficient cause to remove Trump from office. Both were necessary, and here's why. First, when Donald Trump illegally withheld $400 million in security aid from Ukraine and extorted the Ukrainian government into investigating his political rival Joe Biden, the basis for the first impeachment, he not only violated the law, he endangered a struggling young democracy in Ukraine. And he caused other nations, our allies and adversaries alike, to wonder if America is still committed to the rule of law and democracy. In a world in which democracy is under assault and autocracy is on the rise, Donald Trump's role in inciting an insurrection threatened not only those of us in the Capitol building that day, but democracy itself in this country and throughout the world. Second, we now know that the insurrection on January 6th was just the most visible part of President Trump's attempted coup. Every week, with his big lie, we learn more about how deep the rot actually went. We know as a result of an investigation by the Senate Judiciary Committee, which I took part in, that President Trump relentlessly pressured the Justice Department to help him overturn the election. We know that he reportedly considered ordering U.S. military to seize ballot boxes in several key states. And we now know that he regrets absolutely none of it. The big lie continues. In recent weeks, Donald Trump has said unequivocally that Vice President Pence should have overturned the election. And Trump has said he would pardon those insurrectionists of January 6th, some of whom were charged with seditious conspiracy. Trump wants to be president again to have that opportunity to issue those pardons. Assaults on the rules and norms of democracy that go unchallenged become precedent. Impeachment is the constitutional challenge to tyranny. Third and finally, the impeachment trials were necessary because Americans today and in future generations must know the truth. If we ignore history and try to rewrite it for our convenience, we're in danger of repeating the worst of it. That is why the work of the House Select Committee on January 6th and the Senate Judiciary Committee, the continued revealing report on these matters by news organizations, and thoughtful forums such as this one are so important. Our democracy is precious and fragile. By seeking the truth, you reinforce the guardrails that protect democracy here and throughout the world. Thanks for inviting me to be part of your program.
Well, I hope you enjoyed those remarks from Senator Durbin, some, of course, historical and others crafted for our particular occasion. As I was watching, particularly his talk on the Senate floor, I was put in mind of some of the discussions that we've been having in this academic venue over the last day or so, which we talked a great deal about sort of the essential nature of the impeachment process. Is it essentially political? Is it, as Professor Bobbitt, for example, it was particularly insistent upon, is it fundamentally legal? Is it some combination of those things? And certainly I think the answer, both pragmatically and I think on a proper view of the Constitution, is that it's both. But what you saw, I think, I mean, when you saw Senator Durbin's speech on the floor, is both constitutional theory and high politics in action. And you saw also, if you listened, a little bit of an indication of the degree to which the kind of people you've been hearing over the last day or so, and you'll hear more of happily after this hour, the kind of effect that constitutional thinkers and scholars, historians of impeachment have and don't have. on the actual outcome of impeachment. You may have noticed that Senator Durbin referred to and refuted the arguments made on behalf of President Trump by Harvard professor Alan Dershowitz. You might have missed the other thing that he said in response, which is in addition to substantively rebutting Professor Dershowitz's claims, he also placed into the record a letter signed by 300 academics, essentially rendering Professor Dershowitz's opinion a minority of one, which I must say it was. And I know that in part because I wrote that letter with some help from others and with some specific suggestions from Larry Tribe, who was going to be with us, but unfortunately could not be. And you may think, as you listen to that and reflect on those two interjections of the academic world, how important were they? Were they very important at all? Were these sort of constitutional stylings of law professors from fancy places and with fancy degrees, were they of any real importance? Or was all of it realpolitik? Was all of it about convincing, Republican senators, Democratic senators, Republican and Democratic House members to engage in a quintessentially political exercise? Now, I think it's both. I think constitutional theory and history and the realpolitik of everyday life on the Hill and everyday life in America are inextricably intertwined in the study of impeachment, which is why I find it so fascinating. But I hope you picked up on some of the threads that you've been listening to over the last day or so in the real live action of one of the principal actors in this impeachment. So with that, let me throw the floor open to any questions that we have here in the room. I will repeat them for folks online, and away we go. And also, of course, Professor Bennett is here, and he also is here to answer questions that you may have either directed at him or things that he wants to weigh in on. Yes, sir.
So I know Senator Durbin talked about it a little bit, and Professor Call mentioned it in his, when he was talking, kind of about what the benefits are versus the disadvantages of impeaching a president when you know that there's no chance that they will actually be convicted. And based off of Representative Raskin's speech last night too, we heard a lot about how much evidence there was against Trump in the second impeachment, yet there were still only 57 votes to impeach. So I guess this is kind of an open question, I guess, and I'm curious your guys' opinion on it. Given that Trump still wasn't convicted even after the second impeachment and all the evidence against him, where does that leave us in this highly political world, and what do you think the benefits are of still bringing the impeachment even if you know there's no chance that we'll be convicted?
Tommy, I have things to say about that, but I want to yield to you since you haven't said anything.
Yeah, true. So I don't know how well the people on the internet audience can hear the question, but I take it the question, if I may paraphrase it ever so slightly, is how should we think about the question of futile impeachment that with some degree of probability we can be sure is not going to result in removal from office or other kinds of consequences. And as I was listening to Professor Kalt's very learned argument for why these kinds of impeachments are indeed futile, it occurred to me that I guess I'm not so certain what the outcomes of any one political process are going to be. I don't have a high degree of confidence in my own ability to predict what the Senate is going to do from one day to the next. That's just to say that I still think that political processes are in some sense unpredictable. So I'm not entirely sure I buy the premise that there is a degree of certainty that you can be sure that the process of impeachment won't uncover information that won't in turn lead to people thinking about things in a different way that might in turn upend what you thought at the beginning of the process the outcome was going to be. So I think it's a little bit unfair to judge the process in hindsight, knowing that it failed, because at the beginning of the process, I'm not sure it was always certain. And to his credit, Professor Call acknowledged that specifically in the case of the second impeachment, there really was some question in the wake of the events of January 6th, whether there might not be some broad consensus to actually convict in the Senate. So I guess I wish I had Professor Cult's clairvoyance, but I'm not sure that I have it. Though, as he described ably, the rising degree of ideological polarization does make it easier and easier as time goes on to predict these things.
And I'd second the observation about the uncertainty of the outcomes of these things. I think that there is a very significant chance, not a certainty, but a significant chance that if then Minority Leader McConnell had in fact decided to vote for impeachment, that the additional 10 votes, actually 9 plus his, could have been obtained from the Republican side. So I think the end of that case was always doubtful. I think particularly when the impeachment began, I think we got this some from Senator Durbin. We've heard it from others. The explanation of why, for example, the House framed the articles of impeachment in the second case the way they did was, Congressman Raskin went a long way around about this, but basically what he was saying, and I think this was the dominant notion, was that the jurors in the case, the senators, had just had their offices overrun and their lives threatened. So leaving aside the constitutional niceties, in a case like that, where if I'm the prosecutor and I'm considering a jury that is essentially consisting of the victims of the crime, I'm thinking I've got at least a reasonable shot at getting a conviction. So I think the notion, again, that the second impeachment was doomed from the outset is misguided. I think what is shocking is that on facts this clear, that nonetheless, 17 Republican votes could not be obtained. I mean, that I think is a shocking constitutional dereliction. I take Professor Bobbitt's arguments about so-called late impeachments for what they're worth. I think he's wrong for reasons that were explored in the last panel. I think in the end, that argument simply became an excuse for Republican senators who were afraid of crossing Donald Trump. And to engage in some political prognostication here, or I don't know, second guessing, I think some of those folks may well be wondering if their choice was so darn wise, because I don't think there's anybody to be honest, in the Senate Republican caucus who has much use for Donald Trump personally or as a leader of their party. I think privately, almost all of them dislike him personally and find him dangerous to their short and long-term political futures. And I'm quite sure that the vast majority of them would be very happy to have him effectively placed off the political stage. But I think their calculation was that they were afraid to make that statement baldly because they weren't sure and they weren't quite willing to put their political heads on the chopping block. And that, of course, too, has proven to be a real worry. But the real question, or the better impeachment to illustrate your question, is, of course, the first one, where it was absolutely dead certain from Jump Street that you were never going to get 67 votes to convict him on Ukraine. Wasn't going to happen. The fact that you got one, I think, was something of the circumstances was something of an achievement. Two things to be said about that. I do think there can be a genuine political and constitutional utility in bringing forward impeachments, even if the odds against winning are high, partly because I don't think it ought to be said when we're judging constitutional transgressions of a very serious kind by a president that it's an automatic block to proceeding if the president's party simply declares its intransigence in advance. That can't be right, at least on in a case of reasonable substantive merit. But leaving aside the rights and wrongs of it, again, I think impeachment is principally a political process in the large sense, not necessarily in the partisan one. And therefore, I think one has to make some cold-blooded calculations about when it does make sense. And there are going to be many times when, even if the facts are there and at some constitutionally minimal level, it simply doesn't make any good political sense, even any sense in this for the good of the country to proceed. But I think other speakers in the earlier panels have articulated, particularly Congressman Raskin and others have articulated reasons to do it, and I won't repeat those. I think they've said it better than I could. Professor Litton.
So, with polarization getting so bad, and with increasing irrationality in our political discourse, I guess I would worry about impeachment becoming more of a political weapon used, just a political weapon used without integrity. And I was just wondering, given that risk, we've described the process as part legal, part political. On the question of what counts as a high crime and misdemeanor, I doubt the U.S. Supreme Court would ever want to exercise judicial review on, but right, they wouldn't. But I just wonder, A, do you think could they? And secondly, was there any litigation filed before the U.S. Supreme Court on the meaning of the term? Because usually it is the Supreme Court that has the final say on what the Constitution means. Is this a case? I mean, putting aside whether they'd be willing to, is this an exception, or is there still, they would have a final say on what it means, but they would just never exercise. They would never grant certiorari.
I have an answer for that, but did you want to take it?
It seems to me like the clearest example of a political question that would be committed to the discretion of a coordinate branch. And so it's hard for me to imagine, absent complete uprooting of the political question doctrine, which people have been predicting that doctrine was going away for many decades now, and it always seems to come back right when you least expect it. I don't think that there's any clear vehicle to get the question before the court in the way that the court would be inclined to answer it. And it's, of course, complicated by the fact that in cases of presidential impeachment, the Chief Justice has to serve as the presiding legal officer over the trial. So it's especially thorny in the case of presidential impeachment.
Yeah, I second that. I think that the court is, the court, to some degree, like Congress in impeachment, can do whatever it wants. Right? They can wake up some morning and say, well, now we're going to stick our oar in impeachment. And who's going to say no to them if they decide to accept a case, right? But certainly, I think any fair reading of the Constitution itself, which confers the power exclusively on the House and the Senate, which gives the only role the judiciary to the Chief Justice as a presiding officer, I think unless the Supreme Court goes completely cuckoo, they're not going to get into that. And there's one case. Oh, is it Judge Nixon? I think there is an impeachment case where there was an effort made to challenge the proceedings, and basically, that's what it was. The Senate has developed a practice in recent decades, since the 1930s, I think, of not trying at least judicial impeachments as a committee of the whole, and rather delegating the fact-finding process to a smaller committee of senators so they can move on with the rest of the business. And when they sought to do that against a judge, I hope my memory isn't betraying me there.
That's right.
The judge said, "Wait, you can't do that. The law says, the Constitution says, that the Senate is to try cases, and by the Senate, you mean the Constitution means the whole Senate, not some committee of the Senate. and therefore that's unconstitutional. Essentially, the courts concluded that was essentially non-justiciable, or put it another way, that the Senate was in control of its own procedures for trying impeachments by constitutional grant, and therefore, they weren't going to get into it. I think in particular in the case of defining what high crimes and misdemeanors might be, no. And also I think, and here we'd have to go way back to the beginning of the symposium when I started talking about impeachments in the 1300s and Parliament and all that sort of thing. I think any fair reading of the impeachment vehicle and its history in Anglo-American practice indicates that the version that was adopted by our framers quite consciously is functionally, if not in every detail, essentially the one that we had in Parliament, which is to say that this is a legislative prerogative. It is not a power into which the court has, or the courts have, any authority to look. So for lots of reasons, no, I don't think that happens. Yes.
Hi, so my name is Victoria Nantel. I'm a 1L here. So first I'd like to extend my thanks to the Law Review and to all the distinguished speakers we've heard from yesterday and today. And my thanks to you, Professor Bennett, and you, Professor Bowman, for taking our questions. So my questions are about research. Yesterday we heard from Professor Matz as he discussed the sheer amount of research he encountered while serving as impeachment counsel. I'm curious in what ways the internal research regarding President Trump's impeachment was similar to former impeachment trials and in ways it was distinguished from former impeachment trials. I'm curious what was the material and substantive content of the research being conducted by counsel during the impeachment trials, and if there are any other insights regarding the role of research and the impeachment trials you would like to share with us. Thank you very much for your time and your expertise.
Okay, the question for those who might not have heard online was in essence, I'm going to undoubtedly shorten it and I hope not butcher it. The basic question is, okay, what is the role of research, and by which I assume you mean sort of legal research, constitutional research, research about historical precedent, sort of in the practice of impeachments, research by both staff and congressmen and senators. And I think Joshua Matz last night talked a lot about this and talked about how in the two cases he was familiar with, the two Trump impeachments, that the judiciary staff, House judiciary staff, which he was affiliated, did mountains of historical research. Now, I will say that their written output, they wrote a very nice report during the first impeachment. Second impeachment was too hurried for that sort of thing, and the written output was less. But I think the basic process that he's describing is not at all uncommon in the small number of cases we have, right? We only have 4 actual impeachments and 1 near impeachment, which is the Nixon case. But to speak of the Nixon case, for example, which is, we talk about the fact, first thing I'd say is we talk about the fact that impeachment has generally been ineffectual in the sense that we've never gotten an actual conviction, 2/3 of the Senate. I'd say, in fact, there has been one successful impeachment, and that was of Richard Nixon. We didn't have a trial. We didn't even have a formal impeachment. But the only reason that we didn't have either was because it was perfectly plain that he would have been both impeached and convicted. And members of his own party marched down Pennsylvania Avenue to the White House to say, Mr. President, you're going to lose. Go away. And he did. But he wouldn't have gone away had he not been operating in the shadow of this impeachment process that could remove him forcibly. Now, about the Nixon impeachment, you had a bunch of investigative bodies proceeding in what we call broadly called the Watergate matters that led ultimately to Nixon's departure. You had the Senate Watergate Committee, you had the House Judiciary Committee under Peter Rodino, and the Judiciary Committee in particular did an immense amount of very detailed research into impeachment precedents, both English and American. And in fact, if you go into the appropriate places in the records of the House, you will find that their work stands the test of time. It was very, very good. And likewise, in the Clinton impeachment, much less of it, again, somewhat more hurried. But the people involved in that case also did a lot of research themselves. But in the Clinton case, they outsourced a lot of it by bringing in, as I think I said at the outset yesterday, they had 19 law professors and historians come in and testify during a day or two of testimony, and they solicited written submissions from boatloads of other people, and that too is collected. But you might ask, okay, everybody does all the work and they generate the paper and they look at the precedents such as they are and they argue their debatable implications back and forth, but what does it really mean? What I said a long time ago about the Clinton impeachment is this, that the history and such learning as there is about things like the meaning of high crimes and misdemeanors doesn't absolutely command any outcome, because it can't. Because the House can impeach whoever they want, in Gerald Ford's famous words, an impeachable offense is whatever a majority of the House representatives thinks it is at any particular time. And the truth is that the Senate can convict of it anybody that they want for anything that they want. But though they have that theoretical plenary power, experience tells us that research and historical learning and constitutional analysis has a tendency to set sort of the outside boundaries of the debate. Now, the last thing I'll say about that, however, is that sometimes even the most overwhelming consensus among those who've studied this stuff doesn't prevent a majority or a minority from doing what they're going to want to do anyway. Alan Dershowitz was basically the only academic in America who was willing to stand up and say, you got to have a conviction of a crime in order for there to be an impeachable offense, and a variety of other arguments that he made. It was like 4,000 to 1. Okay, Trump still escapes. Second impeachment, you have an argument about the constitutionality of so-called late impeachments. Professor Bobbitt and one or two other people are basically the only people in the academic sphere who argued convincingly enough. I'm not suggesting that it's a totally frivolous argument, but as he himself concedes, he's a tiny minority. The vast majority of other people who've thought about this and studied it say, no, I can't quite agree with this about it. But does the fact that, that the Democratic position would win in a poll of historians and researchers like 500 to 1, does it mean you win? Not necessarily. Must be getting close to the end of time.
I think we've got about 1 minute left before we're going to lose the online audience.
All right.
I've got a question from the audience here. Brian Colt has joined in with a comment here. I don't know if you want to read that.
It says, Professor Colt says, for what it's worth, I agree with both Professor Bennett and Professor Bowman's responses. I don't think the outcome of the second impeachment was clear until after the jurisdictional vote.
Sure. So I have a question here from Bill Thompson, who asks, the Constitution provides that an officer can be removed from office by impeachment. Doesn't this at least suggest that removal is the action being discussed and impeachment is simply the means of achieving that action? And in that context, the proper question is what constitutes grounds for removal rather than grounds for impeachment?
Well, to the extent that I understand the question, it seems to suggest, and I may be misreading it, it seems to suggest that impeachment is only appropriate constitutionally if removal is possible. And I disagree with that strongly, because the two possible remedies upon impeachment are removal on the one hand, but future disqualification on the other. I've written extensively about the latter point. I think the framers were very much concerned about the notion that there could be people, they thought of in terms of demagogues, but basically people who, even if you succeeded in removing them from office at the present, would nonetheless, through their wiles and connections and ambitions, would manage to work their way back into a position of power and endanger the constitutional order in the future. I think it is a severe mistake to think of that portion of the constitutional remedies, that other one of the constitutional remedies, as being a sort of afterthought that has no consequence for the central meaning, the central purpose of impeachment. Impeachment, in the end, in my view at least, is a mode of constitutional self-protection. It is a mode of protection of the republic against dangerous public men and women. And not only the danger that they present in their current position, but potentially danger that they present in the future. And I think it is bordering on constitutional madness to suggest that merely because, for example, in Mr. Trump's case, he committed his impeachable offenses towards the end of his tenure, essentially trying to keep himself in power by unconstitutional means, the fact that he did it so late somehow or other disables the primary constitutional means of protecting the constitutional order from a person who would subvert the electoral process and destroy democracy. So if I understood the premise of the question, which I may not have, and if I did, I apologize, I disagree with the premise.
I think we may be out of time. So.
All right. Thank you so much for coming in, and we will be back online very shortly. think we're about ready to start here. Waiting for my colleagues. Okay, well, my colleagues are coming up. All right, and away we go. Well, hello, folks out there in TV land. We are here for the fourth and final panel of the Missouri Law Review and Kinder Institute Symposium on the future, on the two impeachments of Donald Trump, with our fourth panel titled The Future of Impeachment After Trump, Lessons from Two Acquittals. I hope some of you out there have been watching the rest of this event. I got to say that it really has been special, even for somebody who spent far too much time thinking about this subject. So I've learned a tremendous amount. But let me get right into the next bang-up finale of our production. And to do that, let me introduce our three panelists, after which I will turn it over to them. First with us today is Gene Healy. Gene is the Senior Vice President for Policy at the Cato Institute in Washington, D.C. His research interests include executive power and the role of the presidency, as well as federalism, and overcriminalization. He is the author of Indispensable Remedy, the broad scope of the Constitution's impeachment power, and also of The Cult of the Presidency, America's Dangerous Devotion to Executive Power. Gene's appeared on PBS NewsHour and NPR's Talk of the Nation. His work has been published in the LA Times, the New York Times, Chicago Tribune, and Legal Times, and elsewhere. He holds a bachelor's degree from Georgetown University and a JD from the University of Chicago Law School. I so enjoyed Gene's work on impeachment when I first saw it that I knew I had to meet him in person and learn more about his thinking. So I inveigled him into lunch in DC during a time I was there, and I've enjoyed his friendship and his constitutional insights ever since. Our next panelist is the justly famous Dahlia Lithwick. Dahlia earned her bachelor's in English from Yale University and her JD from Stanford. She is a senior editor at Slate, and in that capacity has been writing their Supreme Court dispatches and jurisprudence columns since 1999. Her work has appeared in the New York Times, Harper's, the New Yorker, the Washington Post, the New Republic, Commentary, and many other places. She is the host of Amicus, Slate's award-winning bi-weekly podcast about the law and the Supreme Court. As an aside, I was honored to be a guest on that podcast to talk about impeachment during the first Trump round. Dahlia was the first online journalist invited to be on the Reporters Committee for the Freedom of the Press. She's testified before Congress about access to justice in the era of the Roberts Court and how Me Too impacts federal judicial law clerks. She's appeared on CNN, ABC, The Colbert Report, The Daily Show, and is a frequent guest on The Rachel Maddow Show. She's currently working on a new book, Lady Justice, for Penguin Press. I think it's fair to say that Dahlia is one of the truly preeminent journalistic commentators on the American legal and political process. And finally, last but certainly not least, Michael Gerhardt, who received his bachelor's with honors from Yale, a master's from the London School of Economics, and a JD from the University of Chicago with honors. He is now the Burton Craig Distinguished Professor of Jurisprudence at the University of North Carolina at Chapel Hill, scholar in residence at the National Constitution Center, and the inaugural Richard Beeman Visiting Scholar at the University of Pennsylvania Law School. The principal focus of his scholarship and public service has been constitutional conflicts between presidents and Congress. He's authored innumerable law review articles and op-eds in major outlets, as well as 7 books. His most recent book, which I'm in the midst of reading, is Lincoln's Mentors, The Education of a Leader. The books he's written most pertinent to our current conversation are those on impeachment. His work, The Federal Impeachment Process, A Constitutional and Historical Analysis, was, I think, indisputably the authoritative modern treatment of the impeachment when I first got into the impeachment racket back in the Clinton brouhaha. And the most important thing, finally, to know about Professor Gerhardt is that his understanding of impeachment is not based purely on remote scholarly meditations in a library. He's been personally involved in both presidential and judicial impeachments for over a quarter century. He's testified more than 20 times before Congress. In particular, in 1998, he was the only joint witness to testify before the House Judiciary Committee on President Clinton's impeachment, and he's been the only legal scholar invited to advise the entire House of Representatives on the law of impeachment. In 2019, he testified in the House's first set of impeachment proceedings against President Trump, making him one of 2 legal scholars to have testified in 2 different presidential impeachment proceedings. In 2021, he served as special counsel to the presiding officer, then Senator Patrick Leahy, in Donald Trump's second impeachment trial. I think it's not unfair to say that Michael is America's premier expert on impeachment theory and practice. And we're honored to have all 3 of you here with us today. So I am, so far as possible, going to try to stay out of this. But I want to just let Gene start with his prepared remarks. And when he's done, we'll throw the floor open to the other panelists to comment or ask him questions. Then we'll move on to Dahlia and finally to Michael. So, Gene, hit it.
Thanks, Frank, and thanks to everybody tuning in. So this is supposed to be our forward-looking panel, and having gone through all that, what have we learned about the way presidential impeachments are likely to work in the future? Well, we ought to have learned a lot thanks to Donald Trump. Say what you will about the man, but he single-handedly doubled the number of presidential impeachments. Greatest president for impeachments ever, many people are saying. And when you get a bunch of new data, you should look at it and see whether you need to update your views. My longtime view from well before Trump took office was that we don't impeach presidents nearly enough. Impeachment, it seemed to me, was throughout American history, had been safe, legal, and all too rare. It's something that we could benefit from trying slightly more often. After all, the framers described impeachment as a really important remedy. For Hamilton, it was the bridle in the hands of the legislative body on the executive servants of the government. Madison called it the indispensable provision for defending the community against the incapacity, negligence, or perfidy of the chief magistrate. And we've had plenty of all 3 in American history. And despite that, over some 230 years of our constitutional history going into the Trump presidency, we'd made only 3 really serious attempts at removing an American president through the impeachment process. Andrew Johnson in 1868, Bill Clinton in 1998, and in between, Richard Nixon, who was never formally impeached, having quit before the full House could vote. That works out to roughly 1 in 15 presidents, a pace that averages out to once every 75 years or so, which is pathetic, it seemed to me. Also pathetic, I thought, were some of the taboos, phobias, and hang-ups that we surrounded impeachment with. Whenever impeachment talk was in the air, you'd start to hear about how it would damage democracy, paralyze government, maybe even provoke a civil war. It struck me as very strange. I mean, America is a country where, among Western democracies, that's probably keener on firing people than most other countries. And yet we had somehow convinced ourselves, even as the presidency got more and more powerful, that the one job in America where you have to commit a felony to get fired is the one where you actually get nuclear weapons. It seemed to me that the historical record, while sparse, was pretty clear that presidential impeachment had never done us any real harm, had never really been a national nightmare. And in at least one case, it had done the country a lot of good. It's true that the process was awkward and cumbersome. In the famous phrase by Lord Bryce, it's a 100-ton gun that requires complex machinery in order to wheel it into position. Still, it kind of worked. In the Nixon case, the threat of impeachment drove a corrupt and lawless and abusive president from office and ushered in a wave of necessary reforms aimed at recapturing congressional power and de-imperializing the presidency. And even when impeachment failed to remove a sitting president, the mere threat and the mere fact of impeachment by the House worked as a sort of form of constitutional censure. Johnson and Clinton survived their Senate trials, but impeachment left a black mark on their legacies. And it made sense to imagine that the threat of that black mark could restrain bad behavior by future presidents. So given that perspective, you can imagine my disappointment when more than 2 years into the Trump presidency, we hadn't yet had a serious impeachment effort. And it's around this time that Professor Bowman and I first met up in person. It was late March of the lunch he was talking about was late March of 2019 at the Dubliner on Capitol Hill. And just a couple of days before that, the long-awaited Mueller report had landed with a kind of underwhelming splat. It seemed at the time, as we met for lunch, that impeachment just wasn't in the cards. And so you can imagine Frank's disappointment as a patriot, a constitutional scholar, and not for nothing, an author of a just completed magisterial history of impeachment for the age of Trump. As we commiserated over burgers and beer, at one point I voiced a desperate prayer to anybody up there who might be listening. Can't we please get at least one impeachment out of this horrifying clown show of a presidency? And I can't help thinking that at that precise moment, somewhere, a finger on the monkey's paw uncurled, maybe two fingers. What we've learned from Trump's two impeachments hasn't caused me to revise my views entirely. For one thing, once again, none of the scare stories about impeachment turned out to be true. But as in the monkey's paw story, there was definitely an aspect of be careful what you wish for about these two impeachments. I've updated my views in the following way. I'm somewhat less exuberant about the good that impeachment efforts can do in conditions of intense polarization and mass partisanship. Trump's two acquittals dramatically weakened the precedent set in the Nixon case. And in each of those two impeachments, Congress wheeled out that 100-ton gun into position twice in the space of about 2 years. And both times when they lit the fuse, it was as if a little cartoon flag popped out that says bang. I should say that the term precedent probably deserves air quotes in this context. Impeachment's a mixed operation of law and politics, and even in the best of times, the politics part tends to swallow the law part. You also don't, unlike in the case of a Supreme Court opinion, you don't have a clear holding and a majority opinion. You're left figuring out the takeaway from how dozens of individual senators bothered to explain their votes. On top of that, the key precedent here, Nixon's, wasn't, as we said, even technically a proper impeachment, since he quit before the hammer could drop. All that said, going into Donald Trump's first impeachment, most people would have said that abusing the powers of the office for political gain was the quintessential impeachable offense. Abuse of power was the focus of the second article of impeachment against Nixon that the House Judiciary Committee passed in July 1974. And the first item it listed was the Nixon administration's attempt to turn the IRS against his political rivals. As John Dean put it in his infamous enemies list memo, to use the available federal machinery to screw our political enemies. The law of impeachment, insofar as we could describe such a thing, the black letter law, and certainly the popular understanding, was that you can't do that. You can't use the available federal machinery to screw your political enemies. Or at least if you do, you're taking a risk of a serious impeachment effort. What Trump had been charged with in his the first impeachment effort was on all fours with Nixon Article 2, naked shakedown attempt on Ukraine's president, threatening to withhold military aid unless and until he opened an investigation into Trump's leading rival for the presidency, Joe Biden. And it wasn't just the fact of Trump's acquittal that weakened the Nixon precedent, it seems to me, but how it was done. It was theoretically possible to acquit Trump or to refuse to remove him from office without catastrophically weakening that precedent. For comparison, consider when Bill Clinton was acquitted by the Senate in his impeachment trial in 1999. Nobody came away from that episode thinking that the message was, go ahead, have a fling with an intern and lie about it in court. You're home free. And that's because, as Professor Gerhardt has documented in a couple law review articles, virtually every Democratic senator who voted to acquit made a point of condemning President Clinton's behavior in the harshest terms: immoral, disgraceful, reprehensible, and worse. That's not what happened in Trump's first impeachment. There was a lot of convenient silence. Worse still, there was, for a plurality of GOP senators, actually seemed to endorse President Trump's description of his conversation with the Ukrainian president as a perfect call. For example, Senator Perdue commented that the president was, quote, just trying to root out corruption in the Ukraine. What, is he supposed to look the other way because it happened to be Joe Biden? Even worse, a number of senators actually embraced the Trump defense team's ludicrous theory that abuse of power just wasn't a thing, wasn't an impeachable offense. Senator Inhofe of Oklahoma said flat out, quote, abuse of power is not impeachable conduct. If only Dick Nixon had known. Then, less than a year later, the second finger of the monkey's paw uncurled. Donald Trump had famously bragged that he could shoot someone in the middle of Fifth Avenue and not lose votes. And the conduct at issue in Trump's second impeachment trial was about as close as you could realistically get to testing that proposition in the impeachment context. The president had deliberately spun up a violent mob hoping to intimidate Congress and his own vice president into overturning an election that he'd lost. Because 10 House Republicans and 7 GOP senators crossed the aisle to vote against their party's president, the New York Times, the Washington Post, and others actually hailed the vote as the most bipartisan majority in favor of conviction in history, which is kind of true on a technicality, but really nothing to pop the champagne corks over. Once again, if you look back to the Nixon case, no vote in the full House, but 7 of 17 GOP members of the House Judiciary Committee voted to impeach. And when Nixon finally relinquished the smoking gun tape, the remaining 10 announced that they planned to switch their vote to yes if it made it to the full House. It was the Republican congressional leadership, including Senator Barry Goldwater, Minority Leaders Hugh Scott, and House Minority Leader John Rhodes, who gave Nixon a final push on the way out the door with a visit to the White House a couple of days before he announced his resignation. In retrospect, Watergate era Republicans' sense of betrayal seems almost quaint. The president had lied to them, and it made them mad. Apparently, they had limits. If you recall Nixon's infamous quote from the David Frost interview, when the president does it, that means it's not illegal. The operating principle in the presidential impeachment context now seems to be a variation of that. When our president does it, that means it is not impeachable. All of which brings me to reassess my initial view. I still think that we perhaps have had too few impeachments in American history. I do think that the taboos and phobias that we've surrounded this process with are unwise and frankly absurd. However, I have reassessed it's the upside potential of frequent impeachments. I think we have to ask, can impeachment really be the indispensable remedy if conditions of mass partisanship have rendered it all but ineffectual? If even the censure function of an impeachment by the House could be catastrophically weakened, particularly if a guy can be impeached twice and win his party's nomination, as seems to be a live possibility. Instead of a mark of shame, impeachment by the House may, in our polarized times, turn into something like a mark of pride, like a battle scar. All of which is to say, well, I think it is occasionally therapeutic to remind presidents that they serve at our pleasure and they don't have an unbreakable lease on the office. Impeachment, the proverbial 100-ton gun, is not playing the role that the framers envisioned for it. Perhaps in part because of the inordinately high bar to removal, the 2/3 requirement for removal in a Senate trial. I still think that we have abundant reason to fear abuse of power in the presidency. I am more skeptical than I was 3 years ago about the utility of impeachment as a effective check on that abuse of power. And I tend to think now that we should focus, our people who are concerned about abuse of power should focus their efforts on structural reforms to the presidency, reducing presidential power to make each individual president less likely or less capable of abusing power. So that's what the lessons I have learned from this very strange period.
Thanks so much, Gene. Before turning to Dahlia for her opening remarks, let me just throw the floor open for a few minutes for questions from either of the other two panelists. Michael, Dahlia, do either one of you either like to comment or ask Gene a question? Michael, you're muted.
Still can't hear you.
Bottom left.
I'll let Dahlia go before me for many reasons.
No, you go ahead. I'm mulling.
Well, Gene, it probably doesn't surprise you to know I'm going to agree a lot with what you said. So let me, I guess, just make a couple comments, but they're also meant to be treated as if they end with a question mark. So take them where you like. One of the persistent, I guess, themes and debates, I guess, that have occurred throughout Frank's absolutely terrific program has to do with what exactly impeachment is. Is it political? Is it legal? My view has always been, because I'm only a master of the obvious, that it's constitutional, and therefore it's legal as a result of that. It's a constitutional process, a unique constitutional process. And that may help, partly designed, as you've kind of well analyzed, partly designed to test whether or not the members of Congress can rise above partisan politics to really consider the dangers to the republic and the necessity for removal and perhaps disqualification. So I'm just curious where you come down on sort of the nature of the process. Sure, it's political, but it's authorized by the Constitution, thereby giving it a kind of legal framework within which this political debate and process may occur. But I'm curious about your thoughts about the basic nature of the process that we're trying to understand.
I think impeachment, well, I wish it was more of a legal process. I think in the old Gerald Ford as a congressman, the effort to impeach Justice Douglas, where the famous, it's an impeachable offense is whatever majority of the House says it is. I've never thought that was true. I mean, there's what the law says, what the Constitution means, and then there's what you can get away with. So if the House had impeached, there's not going to be any review of this process, most likely. But if the House had impeached Donald Trump because he likes well-done steak with ketchup, they could presumably get away with that if they had a majority. But I would not, that's not an impeachable offense. But I think in practice, certainly over the last impeachments at the presidential level have always been highly, highly partisan, and the political aspect has tended to swallow or overshadow the legal aspect. So in practice, that's why we seem to be driven back in every presidential impeachment to some of the old arguments that I think scholars like yourself have convincingly refuted. We're always back to the it wasn't a crime. In the Trump second impeachment, you might not be able to prosecute him for incitement under Brandenburg or something. I think those arguments on the legal side have been just rebutted convincingly, devastatingly, as much as anything has in constitutional law. But they recur because of the political nature of the process. I just, that was always a problem, but I wonder now if it's an insurmountable problem. When you have, particularly in the second case, something that looks like a thought experiment in a clearly, you come up with a clearly impeachable offense, and that there is so little support for it, paltry amount of aisle crossing on that, does make me despair for the utility of it as a remedy. I do wonder if it the shift, which gets virtually no debate in the convention, to the supermajority requirement. I wonder what effect that how devastating effect that has had, and how big a mistake that was. But I don't think there's any way, particularly now, to avoid recognizing that the politics part at the presidential level is always going to swamp the legal discussion.
Dahlia, well, let me turn to you
Can I ask one quick question of Jean, or do you want me to present?
No, I was going to say is you could do both.
No, I think I want to ask one follow-on question, because I love, and it dovetails with what I want to talk about. I love this construct, Jean, of like wheeling in this massive cannon and getting the little Bugs Bunny bang, because I think what you've captured, and it's really hard to make this salient, is that impeachment is both too big and too little, right? Like that, what you're saying, I think, is that if this were a muscle that had been exercised, if it wasn't seen as this nuclear option, maybe we would have become better as a polity at seeing it to be the size that it is. And I guess the question I have, and I think this follows on a little bit to what Michael asked, is if I track your logic, the sort of chilling, inevitable conclusion is, post-Mueller report, obstruction of justice isn't really a thing. Post-first impeachment, abuse of power is no longer really a thing. Post-second impeachment, incitement of insurrection is not really a thing. So it's not just that you're describing a sort of a deflation of the power, the constitutional power of impeachment. You're actually saying that these things that are actually unlawful things that we all agreed upon at one point were unlawful, those are no longer really going to elicit any kind of anxiety, not just from the representatives in the Senate, but from the rest of us too. And I guess I wonder if one of the things that's undergirding your remarks just there are that we're kind of defining presidential unlawfulness down in a way that might be impossible to reverse. I hope that's not what you're saying. I think it kind of is.
Let me think about that. Well, impeachment, I don't want to paint too sunny a picture of pre-2019 presidential impeachment. It was used far too infrequently. And certainly if you were going to come up with a list of horrible things that American presidents had done in American history, the top of your list would not be violating the Tenure of Office Act, lying in court about an affair with an intern, and even in the Nixon case, Nixon justifiably went down for behaviors that at least his two predecessors engaged in with some regularity, which is no excuse. That logic that they did it too wouldn't get you out of a speeding ticket. So I think the Nixon, the impeachment process driving Nixon for office was a positive inflection point in American history. It did, along with the Church Committee hearings and everything else that bubbled up in the 70s, it really educated Americans into how lawless and abusive and corrupt presidents could be. It really deflated the romance of the presidency, and I think that's a positive thing. I don't know that we're certainly don't seem to be becoming more romantic about the presidency as a result of the failure of these two impeachments. I think what it highlights is how blinkered we are into tribal politics, where offenses that you'd be certain if they were presented to either side as an abstract law school hypothetical, you'd get unanimous agreement that this was an impeachable offense. But when you actually run the tape and people's tribal loyalties are engaged, it doesn't work. So, I don't know if it's an overwhelming counsel of despair about where we're going on abuse of presidential power, because I think actually we are in a much better situation than we were than we were prior to Watergate. But I would say we really do have to, I think, reconsider how valuable a remedy impeachment will be if you can't get the cannon to fire.
So I'll talk just briefly, and I want to be super clear in case Professor Bowman didn't make this super clear, that I'm not a constitutional scholar. I'm a journalist. I certainly covered both those impeachments as a journalist. But what I bring to this conversation, and I should start by just thanking Professor Bowman and Missouri Law Review and the Kinder Institute and all of you for including me. This is kind of intimidating and powerful. And I think I also, just as a precatory note, want to just point out that I happen to be in Ottawa, Canada today, covering the what feels like a lot echoes of January 6th. And just really, while the constitutional structure is completely different, and I don't want to go down a rabbit hole of emergency powers, I do think that it's a good frame for my initial framing remarks, which are just that this is a media problem, that the polarization that Jean just talked about, the political polarization, is not just amplified, but I think created by media polarization. And I think the piece I wrote after the second impeachment was entitled something like, "What if they threw an impeachment and nobody came?" Which is just a way of saying that I think that a lot of the failures that, and I totally agree with everything that Jean just said in terms of what it means to roll out a cannon and get just a little bang, and what it means to have a president who sees that as a badge of honor, and that has used that process to completely invalidate the impeachment process. And I think going forward, it will be used to invalidate any attempt to figure out what happened on January 6th. I think that we can sort of lay that squarely at the doorstep of a deeply polarized media. And what I'm reflecting on as I'm sort of trying to cover what's happening in downtown Ottawa in real time is the extent to which there is one media narrative about what has happened. And there are a lot of people who are live streaming themselves on media platforms I don't know about, who believe that the mainstream media simply lies and that everything that is said by government and media is per se a lie. We're not talking about the reason we can't talk meaningfully about Watergate and Nixon is because there's no more agreement anymore on shared facts, on shared truth, on shared reality. And as a consequence, you have a split screen narrative, which I think played out both in the unspooling of the Mueller report, but deeply, deeply played out in the first and second impeachments, when you had networks telling utterly different stories. And it raises this real question of if you can ever get back to a post-Watergate moment of agreement on shared facts. If not on the seriousness of the facts, might not be that we'll ever have a conversation in which we say this is serious or this is unlawful, but to at least say what happened. And I think that that is one of the things that as a journalist, I deeply, deeply worry about, because I think if we can't agree upon what happened, then there's no way to agree on a remedy, whether it's a constitutional remedy, a legal remedy, or a political remedy. And I think that just sort of two framing points I want to make or that I think that one of the things, and Michael touched on this, but I want to say it really explicitly. I do think that the impeachments as they played out just existed in the interstices of a political story and a legal story. And the media is spectacularly terrible at covering either of those two things, but covering the thing that falls into this black hole between the two of them is simply beyond, I think, our capacity to report. And as a consequence, I think you had a thing that was neither fish nor fowl. That at moments, as you thought you were reporting on a legal story, you know, this is the definition of abuse of power. This is a definition of incitement. This is a definition of what are the exceptions to, you know, free speech rules around incitement. You suddenly realized it wasn't a legal story at all. It was a purely political story that was kind of being enacted in a theater that looked like a legal theater, but was not, and that didn't have the kinds of legal consequences that you might think it would. And by the way, this is a problem we're having now covering confirmation hearings, which are kind of quasi-legal, quasi-political stories that we tell badly. And I don't want to sit here and you know, bury the press, because I think the press is not per se the problem. I think it's a much bigger problem than simply reporters. But I will say that I think the inability to pin down, and I'm hoping Michael's going to help us with this part of a story that is neither fish nor fowl, neither a legal nor a political process, really enabled a couple of things to happen. The biggest of which was it just became very easy to, as a media thing, to say this is now just a reality show, right? If it's not politics, if it's not law, now it's just like the Real Housewives of January 6th. And I think that an inability to understand that the public, in some sense, never was in agreement about what it was they were seeing is really profound. And the thing that I really saw, just to sort of dovetail with a little bit of Jean's analysis, is that I thought, watching the first impeachment, not that abuse of power is a classic easy, this is a gimme, right? You're just asking for a thing that you can't ask for as president. I thought it was really complicated. It required immense amounts of testimony, and really complicated testimony about whether that phone call was perfect. My sense going into the second impeachment was that we had video and it would be easy, and that everybody had seen the video. And if they hadn't seen it, they had an ample opportunity at that impeachment to see it. And that there could no longer be an abstract discussion about the thing that seemed like it was bad is actually really good because it was a perfect phone call. Now that went away, seemingly, right? There was a fringe notion that these were good people going to the gift shop, but almost everyone, I think, who saw the video that was played on a loop at the second impeachment could agree on what happened. And so just in terms of like defining, if I'm sort of talking about defining presidential lawlessness now, I think that move from a thing in which there could be no shared agreement about those phone calls, because who really knows what happens, what is diplomacy and what is self-serving abuse of power, all that confusion drains out in the second impeachment hearing, because now we're all seeing the same video. Everyone can agree this looks like an insurrection, whatever word you want to put on it. And to have it still fail to be condemned, to have some of the things that Jean's talking about, which is people actually endorsing and supporting it. And by the way, that's had a long tail, because here we are, you know, a year and a half later, and now it is absolutely endorsed, and they are freedom fighters and should be treated as such. I think raises real questions for me about whether we are ever going to get the public to agree on facts anymore, and whether the media has now completely lost its ability to tell a coherent story that people can agree upon. And the only other thing I want to say, again, before I turn it over to Michael to explain what happens in this land of not politics, not law, is that I think that if it's neither, everybody is immediately absolved of responsibility. And so after the first impeachment, we heard a lot of folks saying, oh, you know, yes, it was super bad, he shouldn't have made the call, but let the voters decide. This will play out at the ballot box in the next election. In other words, we can't make a legal conclusion about what happened, but we can say that the voters will make a political conclusion. And that's the appropriate remedy here. Not a legal answer, not even a political answer qua, the Senate voting on an impeachment, but let the voters decide, right? That was the opt-out there. After the second impeachment, we heard a version of that, which is, we're not going to say let the voters decide. The voters have decided. We're not going to say there is a political remedy here. What we're going to say is, like, the legal remedy should be that charges should be brought, right? That it's not the province of the Senate to make either a political or a legal determination. It should be a criminal justice matter that should be investigated as such, right? And we heard that a lot. And so I think I'm just saying this to set, again, Michael, I'm sorry, I'm really setting you up here, but to set up this question that I have, which is, how do you explain as a journalist the failure of a process that, if it exists to absolve anybody of the responsibility to do anything, played out perfectly, right? Because everyone got to say, hey, this is not, my job here is not to issue a criminal judgment about what is incitement. Let's let the authorities do that. And so I think that is just my way of kind of lashing myself back to what Jean, I think, started with, which is, this is both too big and too little now. That it is both the huge cannon that was rolled out and the little flag that says bang. And in some sense, if the purpose of this process is to ensure that everybody has plausible deniability for doing nothing because some other institution has to do something that isn't me, then in some sense it played out perfectly. But I don't think that was what the framers were anticipating, was to afford everybody the ability to do nothing. And so it raises this question, and it is, I think, the existential question, mapping forward onto what's going to happen when the January 6th committee releases its findings and has its hearings, is what do we do with these processes that seem now to be so fully toothless and drained of power that they in fact exist, as Jean said, to be a badge of honor, to devalue the processes themselves, so that impeachment has become something that is a witch hunt, and the January 6th committee is also a witch hunt, and any legal or political process going forward that seeks accountability is a witch hunt and can never be used again. And that's kind of the grim place that I am sitting at, which is, as I said, defining down not just the misconduct, but defining down the idea of impeachment itself.
Dahlia, before I give this to Michael, I actually had a question for you, because I think I fundamentally agree with what I think to be part of your premise, which is, the failure, if failures they were, of the Trump impeachments can largely be attributed to, I'll call it media failure. I think one of the fascinating things about being an impeachment scholar, or whatever that is, or studying impeachment, is that in fact, to understand impeachment, to talk about impeachment, particularly the great impeachments, you basically have to talk about everything else, because they're just these weird points in the history of America, history of Great Britain, where, everything else somehow or other, all the other crises of the society somehow or other come to a head, or at least some particular crisis comes to a head, and it all gets boiled down into this oddly quasi-legal thing that we've given the legislature to do. But to understand any of the great impeachments, you have to think about so many other parts of the constitutional system and so many other parts of the society in which the impeachment mechanism is embedded. But fundamental to all of that, I think, is the capacity of the society and the legislature that it represents to operate on some sort of substrate of generally understood, broadly accepted facts. The notable difference, I think, between Nixon and the present case, present cases is that, and I grew up in that period. The Nixon impeachment is a principal reason why I became a lawyer in the first instance. It fascinated me so much. But the plain point about Nixon was that it was possible to agree about some fundamental facts. Nobody disagreed about the facts in Nixon. There were Republicans who defended, or at least refused to, profoundly condemn what Nixon did, but nobody disagreed ultimately what he'd done. There wasn't some body of either press, as we called it in those days, when there were such things as presses, or online, avenues of information that were essentially claiming that the thing that everybody agreed had happened didn't really happen. And obviously it's not true anymore. So I guess my question is that a salvageable condition? Because if we can't solve that problem, then the failure of impeachment is the least of our worries. It's a pimple on the elephant's butt. I mean, it simply doesn't matter. And my question to you, and it's one of the reasons I wanted to have you on, because you think about this stuff a lot, is can the media, or more broadly sort of our information ecosystem, be salvaged or at least modified enough that at least a working majority of the country can be induced to operate from the same grounds of reality? Because if we can't do that, we are doomed.
I mean, it's a great question. I think it is the question. It's funny because I'm just preparing for another panel that includes a bunch of judges who are trying to understand the 2020 election, and who keep saying every single one of us dismissed these claims of, massive fraudulent voting and massive ballot tampering. Like, we wrote our opinions, WTF, America. Like, we read what we wrote. And it's the same problem manifested in a different way, which is, I think we as lawyers got very sanguine about legal conclusions being, as you say, sort of translatable into sort of public discourse, and that legal conclusions, even if they were technical and arcane, were still legal conclusions, right? They were not to be disturbed. If every single court throws out, the Sidney Powell lawsuits, why are we still having a conversation about millions and millions of people that simply think those courts are all corrupt? And so I think you're right. Like, that is, in some sense, using your metaphor, the butt of the elephant, right? Because it's not just impeachment. It's that we believed legal conclusions would somehow be comprehensible and binding, and they are not. And I do think that goes to the polarization that Jean was talking about. And I think it also goes to, the sort of law and order thinking about law in America, which is we want to know that there was a crime and a criminal. And that's almost the extent of it. And I'm sure all of you and all of your media appearances around both impeachments had to keep explaining what Jean explained, which is, nobody thinks that having sex with an intern was a crime, right? It's just, we all agreed that it was bad, and lying about it was also bad. And I think that that's what's kind of disappeared, is that I think years and years and years of thinking about the law as kind of entirely constrained by the criminal law got us into a little bit of a situation where we all spent both impeachments trying to decide whether X was a crime. And I think that's just too narrow an aperture. And I think that kind of combined with this media polarization that now is pushing out the idea, not just, that if President X does it and we like President X, then it's, not bad, but that it's affirmatively good. And that we want President X to do it, with the caveat that when President Y comes along and does the same thing, that will be impeachable. And I think that's I'm not sure that this is entirely responsive to your question, but I think that there's this kind of anodyne, like we like to say this vanilla sentence over and over again, which is that this is a civics education problem, right? That if everybody could just learn more civics and watch Schoolhouse Rock, this wouldn't be happening. And I don't think it's a civics failure. That's a part of it. I think it's just an analytical failure where we have no ability now to hear a counter narrative and think it's true. And that's a whatever word you want to affix to that in terms of the sort of complete failure of the epistemic kind of bubble that we're in. I don't think we can have a civics conversation if we don't even agree what civics is. And I'm not sure that I'm answering you, but I think that's the problem we're having.
Well, Michael, before I turn this over to you to bring us into the home stretch, does either of the other two of you want to ask Dahlia a question or make a comment?
My comments will likely be given shortly.
I just wonder how much of this is media driven and how much of it has to do with the presidential systems themselves, because I think there's at least an argument that presidential systems themselves promote polarization. Western Europe got internet broadband and social media around the same time that we did. Polarization has not gone up everywhere. And there's something about a presidential system that seems to lock us into, I don't want to be a person with a hammer and everything looks like a nail, but there is something about separation of powers in a presidential system that seems to exacerbate polarization by making everything seem winner takes all, zero sum. And I think that as we've concentrated more power in the presidency, every time a new president comes in, there's always a series of first day executive orders. But back in the Clinton and H.W. Bush years, they were not that significant. There's the Mexico, there's significant, the Mexico City order. There was the one on, whether federal contractors had to put a sign up saying that you couldn't be forced to join a union. So they're important, but fairly narrow. And in the last 20 years, as polarization has increased and more Americans are, have difficulty understanding each other and, revile the outgroup, whatever the outgroup happens to be, the other team politically, those executive orders have gotten more and more significant, or executive actions in general, and much more turns on which party seizes the president nowadays. Questions about who gets to come to America, who gets to become an American citizen. The amount. It seems to me that we've raised the stakes of our political differences pretty dramatically over the last 20 years by concentrating more power in the presidency. And I don't think it's a sole cause of polarization, but I think in that environment, it tends to encourage the view that every election is a do or die, charge the cockpit affair. And, I think that's something we should be pretty concerned about. I don't know.
Michael, bring us home.
Polarization.
Bring us home.
No pressure.
No pressure at
all. Well, let me just begin by thanking Frank for his extraordinary vision in putting this program together and the amazing people at the University of Missouri Law Review and University of Missouri Law School for putting on a spectacular program. There is a record that will be kept of this, and I think it will be invaluable for generations. So there's not enough hyperbole to describe what extraordinary thing you've accomplished here, Frank, and an amazing group of people, myself accepted, brought together, and I'm hopeful that these conversations will be illuminating, not just now, but for years to come. So I appreciate being included, but I think you should be singled out. There's no disputing that Frank has put on a spectacular program in the Law Review too. It's funny too, as I think about this, because as I've listened to the questions and the comments from Dahlia, Jean, and of course you, Frank, I am struck by the role I'm about to assign myself. My wife always tells me before I go into a program, you're always too depressing. Like you come, it's too, you know, at the end of it, it's like, oh my God, what's there to live for? Well, I'm going to tell a story that may surprise you because I don't think there is as much to worry about as we've just suggested there might be. A good place to begin is a reminder that one of the things about impeachment, which does distinguish it from a lot of other things, is that it tests everyone. It tests Congress, members of the House, senators. It tests presidents if they happen to be the subject of it. It tests the lawyers who are involved trying to staff things in the Congress as well as in the White House. It tests the media. It tests the public. And it even, I think, tests states in certain respects, as we'll see in a minute. So I think what that leads me to conclude is that we take too narrow a vision when we think, oh, it's just political theater and nothing else. It is political theater, but it's also something else. The fact that it's political theater doesn't preclude it from achieving other effects and having certain impacts that I think we cannot ignore. And while I think most institutions failed in certain respects in both of these impeachments, they failed in different ways. And I think that also what we're going to discover at the end of this story is that some of these institutions and some of the people we're talking about actually were more successful than we might have recognized. Let me just give you a couple of examples. In spite of the complexity of that first impeachment, in spite of the political theater, in spite of the polarization, more than 50% of the American people concluded that President Trump should have been convicted and removed from office. That's pretty remarkable. That means that that story, that narrative, got through to some extent. And if you want to see any connection between the thinking at that point and the fact that Joe Biden won by a larger margin than most people would have predicted, and in states that were quite surprising, including my neighboring state of Georgia. Now, I understand demographics and other things come into play there, but if we take a larger perspective and step back just from the day-to-day events of each of those impeachments, I think we can see that those events had ramifications which were not all negative. And some of the players, including the public, may have come out, let's say, wiser than they might have been beforehand. Now, when we look at the second political theater, the second impeachment, 58% of the American people concluded at the end of that President Trump should have been convicted and punished. So that's pretty remarkable. At the end of Clinton's impeachment, you didn't come anywhere near a majority thinking he should be convicted and removed. Richard Nixon, we know. So in a sense, what we've got is, if you look at Richard Nixon's situation, which is really the paradigm, it's when everything seemed to work very well. Media coverage. Congress, and this is not insignificant, took the time. It took 2 years for Congress to do the investigation, which helped bring about eventually Richard Nixon's resignation. And of course, we shouldn't forget the special prosecutor conducting an investigation at the same time. Now, as we fast forward to Trump, Americans don't have the patience they would have had and did have back in the early 70s. And so it's all the more remarkable with the impatience of the American people that these two events and the political theater associated with them still produced an outcome that the public found verified, that Trump not only committed misconduct, but he committed impeachable misconduct, and he should have been convicted and either ousted or disqualified. Those are remarkable things, I think, when we look back on it. The other thing, of course, that's happening in both of those impeachments is the compilation and assembly of remarkable records. Now, Dahlia touched on this a bit. In the first one, there was the House Intelligence Committee and all the work it did, some of which was public, some of which was not. There was the Judiciary Committee, which was largely public, and all that got aired, and maybe it was watched, and maybe it was understood, maybe maybe illuminated some things, but it probably didn't in other respects. But the thing about the second impeachment, as Dahlia pointed out, is every significant thing about it was on tape. And there was a record. And the other thing about it, of course, is as both Jamie has pointed out, and as I know Senator Durbin knows as well, nobody in Congress had any doubt about what everybody was talking about, because they were the subject of the violence. They were the focus of all that violence. So there was no mystery about what happened there for members of Congress. And the other thing I'd add to all this before I launch into more technical commentary is that I appreciate Gene mentioning that in the Clinton impeachment, at the end, even though there wasn't a conviction, more than 67 senators gave statements that thoroughly condemned Clinton. And at the end of Trump's second impeachment, more than 67 senators gave statements that thoroughly condemned Trump. So we got the public largely thinking Trump should have been convicted and removed, and we have at least 2/3 of the Senate in the Clinton trial and the second Trump trial thinking that these people engaged in something really awful, something bad. That's not an escape history. That can't escape any kind of subsequent look at this to try and figure out what was going on. Now, when we get to the particulars about how the impeachment process worked and its particular phases, I'm going to add a couple groups to those that were failures, that failed us in some respects. Understandably, I should add, a big group that failed us were lawyers. One of the things about political theater is lawyers are not trained in political theater. So if you have a process that is largely consists of political theater and lawyers get involved, they are going to drag it down and inundate it with technicalities and confusion. Now, to some extent, that was purposeful. The best defense of presidential impeachment is just confuse everybody. You know, that if I were on the defense side, I'd say, sure, try out these ridiculous arguments and other things because they'll just confuse everybody. But I should note they didn't confuse everybody, which I think is something. But lawyers don't get the subtleties and couldn't communicate the subtleties either. In either of the impeachments, in particular, lawyers who are trained to think courts are the place to go to get things done, to get principled and intelligent decisions. I am doubtful that is empirically true, but a lot of lawyers buy into that. So even in the midst of these two impeachments, think about Jonathan Turley in the first one, trying to turn everything into a legal technicality and to talk about court. Oh, let's take it to the courts first. I understand that was going to delay, and I understand there were political advantages for doing that. But the idea that courts were going to save us represents not just a fundamental misunderstanding of the impeachment process, but of lawyerly obsession with, well, the courts should save us. You saw some of this later, too, with the insistence that Chief Justice Roberts preside over the second trial. Now, some of that was political and partisan. Rand Paul's pushing that, and others are pushing the need to have Roberts sit there, in part because if they could somehow make that happen, it would feed into their narrative that the election was stolen, that the real president of the United States was still Trump. And therefore, if he's on trial, you had to have John Roberts preside. That was partly what was behind all that. Silly, insane, but there's a political point to it. But the lawyers thinking that John Roberts was going to save the day in either trial were not, I should say, good lawyers. That was certainly not clear thinking. John Roberts, no more than William Rehnquist, was going to take an assertive role like Sam and Chase did in the Johnson impeachment trial, and Chase got overruled enough times so that his future political career was ended as a result of that. Rehnquist, having studied the process, understood he was going to do nothing, and then at the end he said, I did nothing very well. John Roberts, a student of history, clerk to Rehnquist, and a very smart guy, understood throughout that first trial, my fingerprints are not going to be on this in any way. Second trial, nowhere to be seen. And quite understandably why he's nowhere to be seen, because John Roberts understood from the get-go, it's not going to be a president on trial. Look, we don't have to make constitutional law all that difficult. If it's a president on trial, the Chief Justice presides. But the president who was in office at the time the trial began was Joe Biden. And under our Constitution, we don't have two presidents in office at the same time. So we can expose that for a relatively silly argument, but for lawyers, they kept insisting, and I would get emails and other things along the way, Roberts could come in and bring some order to this, intelligence and principle and everything else to it. And those are just lawyers who are too hung up on judges, too hung up on thinking the judiciary is always there to save us. If we don't know by now the judiciary is not going to save us, it's too late. That's a myth, and one that I think we should begin to relinquish. Lawyers would also help complicate the quest to figure out what's an impeachable offense. They see that word crime, and they immediately go into their criminal law background and think, oh, we got to set it up and think about it as if it were a crime, which is, as Frank well knows, among other things, is a really bad way to think about impeachment. Yes, everybody who studied the subject understands basically that an impeachable offense is not an actual crime. And it's interesting, if you look at the examples the framers gave at the Constitutional Convention of impeachable offenses, it's almost a description of Donald Trump to a T. Every example they gave fits Donald Trump, and none of them was a felony or an indictable crime. All of them were an abuse of power. Now, as far as Imhoff's comment that abuse of power is not an impeachable offense, I could say a lot of things, but one of which is it's quite striking and revealing that Senator Imhoff doesn't take into account original meaning. How many Republican senators completely ignored, didn't even think about original meaning, never talked about original meaning, never entered into their calculus at all? One reason for that is original meaning is pretty clear here. And original meaning, at least for our purposes, clarifies that impeachable offenses do not have to be indictable crimes, and in fact, often are abuses of power. But let's extend that a little bit as well, because the argument that this might even be a crime and we should wait for the criminal law to do its magic after Trump leaves office misses a fundamental aspect of the federal impeachment process. It is designed in part to deal with things that the law doesn't deal with very well or at all. That lesson was lost on almost everyone, certainly most lawyers who were trying to understand this process. The fact is that impeachment is used sometimes because we don't expect there's going to be a remedy at law. That follows from and is consistent with the idea that if you're going after abuse of power, let's say with Richard Nixon, ordering the IRS and others to go after political enemies, there's no federal crime being committed there. Plainly, it's an abuse of power. Plainly, it's impeachable, and appropriately sought out as a basis for impeaching Richard Nixon. But with Trump, one of the mistakes I think that was made by the wonderful lawyers and people who were involved in the second impeachment is they made it too legalistic. And I think I think Michael McConnell was absolutely right. Had the article in the second one been not crafted as sounding like a crime, it might have made it much harder for Republicans to just ignore it and find technicalities to get around it. The final technicality, of course, which a lot of Republicans tried to hang their head on, as I think Jamie and others pointed out, was jurisdictional. This idea that impeachment doesn't reach to people once they leave office. Phil was one of the more learned people that pushed it back against that. But if we were to look at the history of the actual impeachment process, granted, there was no prior presidential impeachment that extended to somebody beyond the time they held office, but there were at least 6 situations in which the Senate accepted jurisdiction and voted to take jurisdiction over people who had left office. So as far as precedent goes, it's not a hard question. But lawyers come in, and partly, again, deliberately, and partly because they're lawyers, they do a beautiful job of confusing people in a process they knew nothing about or knew very little. Lots of talk about due process, completely irrelevant. Even if it were relevant, guess what? They had notice. They had notice of what was going on. They were invited to the hearings. Nothing's taking place in a secret chamber. And the other thing about due process is you need a neutral or independent decision maker. Guess what? The Constitution assigns one. It's called the Senate, which is supposed to be neutral, independent. That's why they take the oath. Now, whether or not it performs that function is no more of a tough question than if we'd asked whether an arbiter really does it or whether somebody else who's trying to run a trial is really doing it. Sometimes they perform that task well, and sometimes they don't. But the Senate as an institution was itself put on trial. And the Senate as an institution fails. And that's partly because of the design of the Senate. It's not designed to be a purely small d democratic institution. It is, of course, designed to be counter-majoritarian. It's designed to be anti-democratic because the people who designed the Senate were the same people who designed impeachment, and none of them trusted the public. So what do we have in the Senate? We have a situation in which we could have 58% of the American people thinking there should be a conviction, but you still get 43 senators who won't vote to convict the president. I still think 57, as Frank and I think has pointed out and others have pointed out, is a pretty significant number. And that number will be important historically. So, and if we expand our vision just a little bit, then we recognize that impeachment, while it hasn't resulted in a conviction and removal of a president, it has stained presidencies. It also likely has had a deterrent effect. There were times, and this is harder to measure, but we can see glimmers of this throughout the Trump years when White House counsel threatens to resign if Trump fires Mueller. Later, Pat Cicilline threatened to resign if Trump kept trying to interfere with the election and all the rest. Trump kept doing it, but Pat never resigned. So Pat falls into the category of disappointing lawyers, caring much more about their own political futures and their own legal careers than they do about the health of the nation and the importance of the Constitution. Just to wrap up my initial comments, I think it's also important to recognize that not as far as the second impeachment was concerned, there were a lot of things I think that were connected to that are still playing out. So we don't really quite know the full impact that event's going to have, not just on Trump, but on the presidency itself and the nation. So, for example, we know now something we had suspected and heard about a lot through each of the two impeachments, and that is a lot of people in the White House were destroying documents and abusing power. So one thing I think about that is how, yet again, lawyers failed us, and some of those lawyers should be disbarred. It isn't just the lawyers who challenged the election and filed ridiculous lawsuits. People who went into government and White House and elsewhere, who lied to the public, facilitated criminal or other illegal behavior, they should be held accountable. And they may not be. That could be a failure of the ethics system as well. But Pat Cipollone, when he came in front of the Senate the first time, just spouted a number of falsehoods, which lawyers, by the way, should not be able to under Rule 3.3, 8.3, or 8.4. And he's gotten off scot-free. But the thing is, there's a record for all time for people to see that. And I think the longer time passes, the more it's going to be likely that any public that see that, any students that see that, any scholars that see that, any members of Congress that see that, they're going to see that the record against Trump was stacked both times. And Trump might have eluded things, as people sometimes do, but that doesn't mean they didn't pay a price and won't pay a price in the long run. So I think if we broaden our perspective a little bit, impeachment has more sting than we might recognize that it does. The public got it. Some lawyers rose to the occasion, others didn't. And some members of Congress rose to the occasion, others didn't. But most members of Congress in the House and the Senate condemned Trump both times. And that's not insignificant because it doesn't happen to every president. That may be a good place to stop. But I'm just getting started.
Thanks so much, Michael. That's wonderful. I'm going to throw this over to your co-panelists here in a second. Just one observation that occurred to me as you were talking about how the effects of impeachments can linger. I think sometimes they linger in ways, obviously, that are not immediately obvious at the time or even shortly thereafter. And sometimes, because I'm working on this second edition of the book, I've been working through the history of impeachments again, beginning at least with Nixon and Clinton and up to Trump. And I think that there's an interesting through line in all of them. There are both tenuous and obvious connections between the people involved in all of those actions, and also the themes and the effects that sometimes lingered and didn't surface for years later. So, for example, Hillary Clinton gets her start as a lawyer, as a staffer on the Nixon Judiciary Committee. She then, of course, becomes the wife of the president, who gets himself impeached. It's been remarked several times today that that Clinton's impeachment didn't affect him or his popularity in the short term, which is surely true. But I think that's not necessarily true, because people approved of diddling the interns in the White House hallways or lying about it. I think it was, as much as anything, was a reaction against Clinton's opponents. and their overreach.
I think it hurt Al Gore, though.
Pardon? Well, I think it did, and the next point I was about to make is that in the long run, I think the besmirchment of the Clinton brand, if you will, extended certainly not only to Bill himself, but also extended to his wife. Many people felt, rightly or wrongly, that her defenses of him, at least sometimes during part of that impeachment, reflected poorly on her. And I think the general stain on the Clinton brand persisted long after Bill left office. And certainly the impeachment was not the only thing. I mean, the Clintons were the recipients of, sometimes rightly and sometimes less so, of all sorts of attacks and character assaults over the years. But I do think that, you know, the sense of distaste about the Clintons as a couple, and although, you know, Hillary Clinton's fans and supporters would certainly say it's unfair to assign to her the sins of her husband and so forth and so on, but in the end, human nature is not going to do that. And in any case, she plainly allied herself with her husband, stayed allied with him even after his disgrace. And I think that lingering stain was at least part of the problem that she carried into the 2016 election. And, you know, the last point I would make on that is we simply can't know what the ramifications of the Trump impeachments are. Maybe the record that you speak of, maybe the branding of his behavior as impeachable will have a beneficial effect. Maybe it won't. Maybe we really are doomed. Maybe, you know, the system utterly failed, and because of, you know, media's disintegration and a variety and political polarization, these two failures are, you know, the forerunners of our, you know, general degradation as a political civilization. But we just don't know. And one of the advantages of looking at impeachment in the historical perspective is you realize that, you know, the stream continues running for years, for decades, sometimes for centuries, and you don't know what the effects are going to be in the long run. So that's the last thing I'm going to say in this panel, but let me turn things over to Dolly and to Jean to ask any questions of Michael that they would like to, or make any comments they would like.
I was just going to, jumping off of your last comment there, think of how we've reevaluated the Johnson impeachment over time. You know, the Johnson impeachment in the early part of the 20th century was sort of, you know, that hokey movie about, you know, Johnson getting impeached. And it was sort of viewed as a fundamentally unfair embarrassment. And I think in the last 30, 40 years, we've come to look at that impeachment in a different light. So you both managed to cheer me up a little bit on the constitutional censure function of impeachment. It also occurs to me that you know, Trump in so many ways was sui generis, if that's how you pronounce that, that he undeterrable in some ways, but most presidents tend to be highly legacy minded. And, you know, while he may view it and some of his supporters may view it as a badge of honor, it's unlikely that the sorts of people who typically seek out and win the office are going to think, are going to be neutral about the prospect of being impeached, because historically it hasn't ended up, it has been a black mark. So thanks for the ray of optimism in all of this.
I do what I can.
Yeah, so my podcast producers pet name for me is Broken Tigger, because I used to be sort of bouncy and optimistic, and I'm just destroyed. So I am, let's stipulate, uncheer-upable, unlike Jane. But I do want to maybe connect something. I want to make an observation about something that Jean said, and then I just want to ask Michael a question. It was interesting, way, 45 minutes ago, I think, Jean, you made this really interesting point about, part of the pathology here is that there's just too strong an executive branch, right? The stakes are too high, and that's why we need systemic fixes. And I've always said that, and yet listening to you today for the first time, I thought it's interesting because that's the knock on the Supreme Court right now, right? That we have a Supreme Court that is far too powerful, and impeachment is not a solution, and therefore we need systemic fixes. And I wonder, how that sort of braids into the conversation we've had today, because I think a lot of the pathologies you're describing about the executive branch are also, I think, easily at this moment have been ascribed to the Supreme Court. But I do also want to just ask Michael, because I think you've made such a compelling case for, the system didn't buckle entirely and lots of things worked as designed. But I'd love to hear, and I bet listeners would love to hear, if you have a little laundry list of, you've talked about the lawyers, you've talked about, accountability for people who destroy documents. And that's certainly, I think, interesting in terms of reforms. But do you have a sort of a handy dandy back of a napkin list of things that you would reform tomorrow to make the next impeachment not a complete failure as you've described, but something closer to the aspiration?
And I appreciate the question. So if it's okay, let me answer that one last, though. I'm going to answer it, though, I promise. But I'm going to sort of try and bring together the things Frank mentioned and Jean's mentioned, and maybe some other themes. So to begin with, I take your point, Frank, about the significance of an event. We may not know it. I think that is inextricably linked to the nature of precedent. So what we're really dealing with these impeachments in the House and trials in the Senate, each of those is a precedent, and their value and meaning is only determined later. It's not really determined at the time it comes down. It will only have meaning and significance later, to the extent others invested in it one way or another. So we're still waiting for that. But here I'm going to respond a little bit to there's a question about, well, will impeachment become our, an annual event or something? Here, Jean, I'm sorry to say, I don't think people come out of impeachment with a taste for impeachment. They always come out of impeachment with the taste that, oh my God, I never want to have to do that. It was an awful thing to have to go through. I took a survey of the senators at the end of the Clinton trial. They basically all came down on that regard. And I think you're going to see it at the end of the two Trump trials as well. American people don't have a taste for it. I don't really think Congress develops much of a taste for it either. Now, events sometimes compel these things, and we'll get to that. On the second point, with regard to how things have been degraded, I just want to alert everybody, particularly the listeners. There's a great book, and I think we all know it, by Ken Gormley, by The Death of American Virtue. It's really written about in the aftermath of Clinton's impeachment trials. And although I don't agree with everything Ken says in it, it's a meticulously researched and very valuable book that does sort of, to some extent, recognize that the Clintons may have been a party to or involved with or may have embodied the kind of degradation of a virtue that's always going to be hard to recapture, always hard to revive. But this is just a reminder that impeachments don't happen in a vacuum. They're really connected with their culture, the time, politics of any particular era. Next point was, I wanted to just add something else about the lawyering in the impeachment process. This is not a knock against the terrific lawyers like Joshua and others who worked on the first one, or Jamie was magnificent in the second one. But I think that one of the things lawyers might have unintentionally done is develop impeachment articles which were not as finely wrought as perhaps they should have been. I think they became a little too technical. And here I'm thinking, Jamie himself said, I think the first one should have included, it was hard to escape this, all that self-dealing. I mean, all the self-dealing was a massive reflection of Trump's and evidence of Trump's corruption. And to leave that out, for whatever reason, I think could be construed as giving him a pass. And that's not a good thing. Now to the question, like, what would I do to reform the process? Well, I've had a few different ideas, and I'm starting in a very strange place. I grew up in Alabama, which is a very strange place. And yet, Alabama, I think, demonstrated the utility of an impeachment-like process twice when it came to Roy Moore. In the state of Alabama, the way the procedure is set up is there's a court of inquiry, and it largely consists of members of the bar. And it is stunning to think that members of the bar came together with lower court judges twice to toss out the elected Chief Justice of the Alabama Supreme Court. I can tell you in the state of Alabama, that's a very brave thing to do. That takes a lot of chutzpah. A lot of really fortitude. And so it may be a lesson for all of us that maybe Congress is not the place to expect to deal with these kinds of issues. Now, but we all know a constitutional amendment would be required. Who would we give it to? I still think if we could give it to a group that's not as invested in the political future of the party or the presidency, as is the case with Congress or partisans, and what group that might be, I couldn't tell you, but I still have a lot of faith in things like the ABA Committee on the Judiciary, which does a fabulous job in reviewing Supreme Court qualifications of the nominees. So there may be voices out there, perspectives that are going to be better consulted on something like this than I think asking people who are captured by their party. Now to get to the more realistic things. I think that one of the things that was a really great development in the Nixon case, we can take a lot of good models from that. One of the really noteworthy features of the House Judiciary Committee that was investigating Nixon is they had one staff. It wasn't two staffs. It was a joint staff. Republicans and Democrats all comprised one staff. And that report, I agree, Frank, has withstood the test of time. It was magnificent. It's a great piece of work, not just done by the staff, but by historians from Yale and elsewhere who came together and really put together, I think, assembled what is really the gold standard for these kinds of things. And I think that's a lesson. So if we could find a way to have one staff, not just these combating staffs, that could be a step forward in trying to professionalize and also increase the credibility of the staff's work. And maybe one way to do that is to reach out, not so much for impeachment experts, but let's pull together some really, some people who's, let's say, who are terrific historians, whose reputations and skills are all on the line when they're asked to kind of pull together the history of something like this. Another change I would make is a lot of people think, and I think I'm friends with Norm Eisen. I think he's great. Barry Burke was great, and all the rest. And I'm not sure yet whether having counsel ask questions it helps or not. And the reason I say that is because the public generally doesn't like lawyers. And so if you put a lawyer up there in a way that kind of highlights all their wonderful skills, we get it. We see the value of it. But I'm not sure how it plays in Peoria. And so I think, but I have a solution to that. And the solution, and I don't want to cause problems here because I could think of these people as my friends and I respect them and all the rest. But think about Arthur Lyman when he's brought in for the Iran-Contra scandal. Arthur was an institution at that point. You bring in an Elliot Richardson, you bring in somebody who has such enormous credibility and integrity and stature to be that lawyer. Hopefully for both sides, but if you had to have it for each side, that's going to raise the performance level of whatever goes on. This is not again, the performance level of Joshua and others was fantastic. I'm not A+. I'm not knocking that, but if we're thinking to the future, what could be different, what might work slightly better, I think if you find those folks out there, and they are out there, who come in really without anything to gain, except this is their public duty, this is their public service, I think that could be a positive development. Another thing I think would be helpful is to do more work with the media. And I mean on background. So this is not a problem with Dahlia, not a problem with a number like Peter Baker, but the farther we go, the more distance we move away from people who are really tuned into this, we're going to confront people, whether is on cable or elsewhere, who don't know anything about it and have to relearn it from the bottom up. Frank, you may have found this to be true. One of the most frustrating things to have to experience in all these different impeachment proceedings is that nobody learns anything from the last one. You know, didn't I just tell you like 6 months ago what high crimes and misdemeanors represent? And here we have to go through it again. And part of that is because the lawyers and defense counsel are trying to create all sorts of confusion and rely on flawed history and all the rest. But I think to the extent people can work with the media to make sure they're well informed is a great thing. And then I think as far as there's not going to be a perfect solution to the polarization, but what I would suggest there is I think the media could do a better job at exposing the paucity of the substantive positions that some people are putting forward. And so you bring in for an interview, you know, Collins or somebody else, or the great Matt Getz. You know, God, I'm sorry. I'm being sarcastic there in case anybody needs verification of that. And just see what they do when they're questioned. And I'll finish on this point, and it's a pet peeve of mine. And that is, and I think, Frank, you've seen this, and you and I may be of one mind. I'm not sure on this one. But to bring in people who are really just there because they see it as their civic duty. You know, I get a call, I see it as a great honor. I'm going to try and do it. If Noah, Frank, Pam, whoever it is, they come in, that's fine. But when we have people yelling at us, and those people are members of Congress, it's an unfair fight. Because for one thing, they're elevated. And for another thing, we can't talk back without being cited for contempt of Congress. But they sure as heck are abusing their power when they who are being paid by the public, I'm paying their salary, and we who are not being paid at all to do this, when we're trying to do our duty, and members of Congress are, in a sense, abusing their authority, somebody should call them on that. And if it has to be me, so be it. But I think it is an unfair fight when a senator goes after someone. Deborah Lipstadt and the Senate, we all know about this with Ron Johnson. Deborah Lipstadt nominated an ambassador because she is the world's expert, basically, on the Holocaust. And she is demeaned and ridiculed by people who don't even understand or have read her work. There needs to develop a mechanism for holding that kind of abuse in check.
Well, you just came right up to the last second mark of our allotted time.
Sorry.
Perfect. Thank you all so much. As always, I learn things every time I talk to any of you, and today was no exception. I'm extremely grateful to all you folks, to Michael, to Dahlia, to Jean, and also to the other wonderful people who were with us before. I'm particularly grateful to the Law Review folks for setting this up. I hope they appreciate your very kind remarks, Michael, because they certainly deserve all the plaudits that we can give them for putting together this, and also will deserve even more plaudits for editing the wonderful written productions that I'm sure you guys are going to generate in a timely fashion for those lovely folks at the Law Review to memorialize your thoughts forever. But thanks also to the law school, to Dean Litsky, to Dean Litton, and particularly I want to thank on the Law Review staff, Gunnar Johansson, who was the executive, I forget what his title is, but it's a fancy title, but more importantly, he was the lead guy and did essentially all of the laboring work that made this seminar, this symposium possible, and I can't thank him enough. So with that, you were released from bondage, and we thank you so much.